are back after a break. It's just 11 right now. By the way, when I speak a time, I am not referring to any of the mismatched clocks in any of these hearing rooms. I've never seen 2 clocks agree in any hearing room. So, um, glad for their hospitality. Anyway, Mr. Real, if you would resume.
Thank you, Madam Hearing Officer. Deputy Secretary, you talked a minute ago about having ordered that a comprehensive performance evaluation be done on the CRRUA system. Is that correct?
That's correct.
Can you elaborate on the comprehensive performance evaluation and what its findings were?
Certainly. So, as I stated earlier, the comprehensive performance evaluation looks at all aspects of an operation, everything from the day-to-day functions of the system to how it's managed, to how it's financed, to its accounting processes. It looks at SOPs that are utilized by staff to operate the system. And it looks at guidance and training that's given to that staff to operate the particular system. In this particular case, the CPE identified that there were no written SOPs in place to direct staff in how to operate portions of the system, and specifically the arsenic treatment units. There was no directive with regard to what levels were to be maintained, the amounts of chemical that were needed to be utilized to maintain pH and to take out the arsenic. There was little to no training of the staff that were actually there. It looks at the manning. It was determined through the CPE, and this was no news to us or to CRRUA, that they were severely understaffed, that they needed many more people to operate the system. It was established that the bulk of the system is manually operated, and you physically have to have somebody pushing switches, turning valves, and taking measurements to adjust the quality of the water and to treat it. They looked at the financial side and identified that in fact CRRUA's budget was not sufficient to adequately operate the system. And I will say it also looked at the structure of CRRUA. CRRUA is overseen by a board made up of members from Doña Ana County and Sunland Park, who are ultimately the ones that have authority over what happens with the system. It was identified, because some of those board members were interviewed as part of the CPE, that there was not a real good understanding on the part of the board with regard to what went on operationally with CRRUA. Staff were not fully trained. At the time, they did not have operators that were certified to a level to operate the system. CRRUA did move forward to create many of those SOPs and get things in line. They did contract with a level 4 operator, and it was identified that their rates are not sufficient to cover the operation of the system. It was also identified that the CRRUA board had approved a rate increase several years ago. For unknown reasons, it was not put into place. CRRUA did take that step to initiate that rate increase late in the year, but that rate increase in and of itself was not enough to give them budget to operate. One of the recommendations was that they look at additional budget increase. I believe CRRUA did contract an entity to do an evaluation and look at another potential rate increase, but that has not come to fruition yet. The indication from the comprehensive performance evaluation overall was that the system was not being adequately and appropriately managed in a manner that would protect the public and allow them to fully comply. And as I stated, we found no SOPs in place initially. They do have them now, but those SOPs, that's a part of any operation. They should have been in place long before this. And I think it's indicative of the fact that CRRUA is responsive when they get caught, but not so much so whenever they're not under close scrutiny. And that's a significant part of why we're here today.
So, Mr. Secretary, is specifically with CRRUA, as you just described, why did you feel the Drinking Water Bureau had to assess the penalties described in the 2024 ACO?
Well, number one, I'll go back to an earlier statement. The fact that there was an intentional decision made to shut down a portion of the system, the arsenic treatment that is critical to protecting public health, and then what we can only assume is an intentional decision not to report that, not to notify the public, is an absolutely egregious violation. In fact, almost criminal, in that people were knowingly put at risk. And that is the primary driver. Obviously, all of our work with CRRUA up to this point, all of our compliance assistance over the years has not changed the mindset with how this system is managed and operated. And that is critical if we're ever going to be successful in protecting the public.
Thank you, Mr. Secretary. Let me take you back to the inspection that you ordered on Saturday, December 2nd, 2023. Who was present at the 2023 inspection on CRRUA's behalf?
I believe that give me a second to think. I believe that the current director was there. I do not recall if the director at the time, Brent Westmoreland, was present at that inspection.
Okay. When you're referring to the current director, are you referring to Juan Carlos Crosby?
That's correct.
Okay. And Mr. Crosby is is now the current director. Who was the former director of the
Former director was Brent Westmoreland.
The intentional bypassing of the treatment plants, the sensor not being calibrated or replaced correctly, that all occurred while Mr. Crosby was the assistant executive director. Is that correct?
That's correct.
Would it be fair to say that Mr. Crosby had the authority and the ability to call and report those issues to NMED in the same manner that that the director or an operator would have?
I believe he had that authority and ability, and in fact had a legal obligation to do so.
Okay. It's my understanding that Mr. Carranza, who was the lead operator of CRRUA at the time, at that inspection and at the sanitary survey, which took place on December 5th and 6th, that he informed your staff that, as you said, the arsenic treatment plants have been taken offline for over a year. That would mean that citizens had been drinking potentially or probably certainly contaminated water for over a year. Is that correct?
That would be correct.
Is it fair to say that during the 2023 sanitary survey, a large number of significant deficiencies were identified?
That's correct.
Okay. To your knowledge, have they all been resolved as of today?
To my knowledge, they have not all been fully resolved.
Has CRRUA ever applied to your office for any funding, Mr. Secretary, to help them meet these goals?
I am not aware of any recent applications for funding to either my offices, which would be the Construction Programs Bureau, or to other funding entities within the state.
Are there funds available for struggling water utilities?
Certainly there are. There are millions of dollars available through the Drinking Water State Revolving Fund, essentially funding through our rural infrastructure program. And there's numerous other sources of funding that the state has put in place through the Department of Finance Administration and New Mexico Finance Authority.
What does it tell you that CRRUA is struggling to maintain the standards of the system, and yet it has not taken the opportunity to even apply for these funds?
It indicates to me that there is a lack of focus, a lack of commitment, and a lack of proper prioritization of activities and actions to protect the public health.
In his role as executive director, has would Mr. Crosby be able to apply for these funds from your office?
He would certainly be able to apply for those funds. I am not aware of his authority, since they're governed by a board, on whether or not he could accept those funds and enter into an agreement, but there's no obligation when you apply to take the fund.
Has Mr. Crosby ever reached out to your office about this funding?
Not that I'm aware of.
Has your office reached out to him, Mr. Secretary?
Our office has reached out to them. Funding has been discussed numerous times by drinking water staff with regard to what's available.
And did you ever hear back from Mr. Crosby about the funding?
Not that I'm aware of.
Okay. Is it safe to say, in your opinion, Mr. Secretary, that CRRUA is a habitually bad actor?
I believe that's what is indicated by their history and even by the current situation that we're seeing now.
Is that what their inability to maintain compliance without lapsing back into non-compliance indicates?
It does indicate that systems should be able to operate in a manner where they anticipate problems. For example, if you know that the arsenic level is 10 parts per billion, and you know that if you exceed that, you put the public at risk and you're in violation of the regulations, you would typically operate your system so that it never gets close to that. Now, one of the things that was identified in the comprehensive performance evaluation was the fact that, as I said earlier, much of the system has to be manually operated. That means that the only time they know there's an exceedance is when they go sample for it. As part of the CPE, it was recommended and in fact directed that they install a automated system, what we'll call a SCADA typically, that would monitor the water quality, that would operate the equipment, that would send an alarm to the operators the minute they started to see a change in the system, so that response could happen before the exceedance. That has not occurred yet.
Are you aware that CRRUA has requested what's called a good faith reduction in the penalty on this administrative compliance order?
I am aware of that.
In your opinion, do you think that CRRUA is entitled to a good faith reduction?
Mr. Real, I don't listen to settlement discussion factors.
Okay.
And I didn't see anything in the pleadings so far from CRRUA on that point.
Mr. Trujillo this morning mentioned that they requested a good faith reduction in his opening. Right. Right. Okay, let me rephrase my question.
All right.
Mr. Secretary, in your penalty policy, is there something known as a good faith reduction?
Yes.
Under the current circumstances, knowing what you do about CRRUA's water system and its operations, do you think CRRUA is entitled to ask for a good faith reduction?
No.
Why not, Mr. Secretary?
Again, we're dealing with a situation where the water system is responsive essentially only when they're caught. And then, they have moved forward after the CPE with putting into place some of the requirements in that CPE, but no indication. In fact, no activity initiated solely by CRRUA to enhance or improve the situation. It's all been reactive. It's all been directed by the department. That does not indicate a willingness to me to really lean in and do what's right to ensure that the public is being provided the product, the safe product that they're entitled to.
In fact, Mr. Secretary, isn't your office seeking to apply a bad faith enhancement to the penalty assessed against CRRUA in this action because of their actions since receiving the administrative compliance order?
That's correct. There have been exceedances of the arsenic standard during this time. And while those don't necessarily constitute a violation of the arsenic standard because it is calculated on a rolling 12-month average, the reality is that those spikes, those exceedances, expose the public again to a health hazard.
All right, we're walking this line, Mr. Roderick, because as I understand it, the division has another witness who's going to talk about the health hazard. Thank you.
Mr. Secretary, does CRRUA deserve the bad faith enhancement in your opinion?
I believe they do.
And as that, would you elaborate on that and why they deserve it?
Well, again, the anticipation is that you manage your system in a manner that does not allow exceedances to occur. Now, they may occur due to an unforeseen equipment failure or something of that nature, but when the system is operational and you have exceedances, it's an indication that you are not monitoring and managing the system appropriately to anticipate that and react to increases in the arsenic level in the water before they cross the barrier. That's not good management of the system. That's not appropriate management of the system. And the fact that CRRUA has not moved forward with putting a SCADA system on, which would assist them in doing that very thing and would in fact reduce the level of manpower that is required to physically go monitor and check these things, and would allow the system to react as changes occur rather than wait for human intervention, is an indication of either poor management or lack of concern.
Mr. Secretary, if CRRUA isn't going to take the necessary actions or is unwilling to take the necessary actions to protect its consumers, who has the obligation to protect those consumers?
That obligation falls to the New Mexico Environment Department, and if we fail to meet that obligation, then the U.S. EPA will step in and do so.
And is that why we're here today? Is that why you issued the administrative compliance order?
That is exactly why we're here.
Thank you, Deputy Secretary Roderick. I have no further questions at this time. I reserve the right to
Redirect?
Redirect.
Yes, sir.
Thank you.
All right, thank you. Mr. Trujillo.
Madam Hearing Officer, we are going to break right at noon or before then.
Yes, sir. We do need to break at noon. If you would just get us as close as possible to it.
I'm sorry.
Yes, get us as close as possible to noon with your questions, and we'll break for 1 hour. I'm back at 1, and I'll invite public comment.
Sounds good. Thank you. Mr. Roderick, I believe you testified that NMED has primacy to act on EPA's behalf. Is that correct?
That's correct.
You also testified that NMED, in doing so, applies federal statutes.
Correct.
Is that correct? And you testified that you are an expert regarding requirements to comply with regulations. Is that correct?
Correct.
And wonder, would you believe it would be important to be consistent in the application of, or consistent regards to compliance with regulations on part of CRRUA?
Yes.
On the part of NMED?
Yes.
Are you aware of 40 CFR section 141.23?
Yes.
I'll just represent to you that NMED has adopted 40 CFR 141, the entire section, and incorporated into NMED's drinking water regulations pursuant to section 2710-100. Is that correct? In other words, they've adopted the CFR.
Yes.
And I believe that with your testimony is that NMED then follows the CFR, applies the CFR.
Yes.
And so are you aware that 40 CFR 141.23 only allows for arsenic sampling to be taken from each entry point to a water systems distribution system that is representative of each source after treatment?
I'm going to object. This is irrelevant to the ACO that we're talking about today.
Mr. Trujillo?
Yes, Madam Secretary, Madam Hearing Officer. Cross-examination extends to matters that may modify, supplement, contradict, rebut, or make clear facts testified by a witness. State versus Baca, 1970 NMCA 075. Rule of Evidence 11607 states that any party, including the party that called the witness, may attack the witness's credibility. It's called impeaching the witness. Right to impeach witness is basic to a fair trial under McIntyre's Inc. versus V. Hill, 1979, NMSC. I'm so sorry. I'm so sorry. It's called MAC, one word, Tires, TYRES, Inc. versus V. Hill, 1979, NMSC 0110. I think that multiple courts have stated that there's a constitutional protection of right to cross-examine fully, including impeachment of the witness. I believe that the witness has testified multiple times that he is an expert in compliance with regulations. He's testified that NMED administers the CFR that it's adopted. NMED is to follow the CFR that it's adopted. And so this line of questioning is directed to NMED to test the veracity of that statement.
Madam Hearing
Okay.
Officer,
Yeah, Mr. Real.
that wasn't responsive to my objection at all. What I'm referring to is the testing samples that Secretary Roderick testified about were all taken at entry points. They had nothing to do with the samples that Mr. Trujillo is trying to bring into evidence here. And so I don't understand how he is rebutting anything or is he's questioning my witness about something that my witness didn't testify to.
Okay.
What I'm doing is I'm impeaching the witness on his statement that he is an expert in the regards to requirements to comply with regulations. And I'm impeaching that statement. He stated that NMED complies with the CFR with its own regulations, and this line of questioning directly rebuts and impeaches that statement.
Okay. So, yeah,
Madam Hearing Officer,
Mr. Real.
the application of the regulations at issue were about tests that were taken at entry points, not about the test that Mr. Trujillo is trying to bring into evidence. Is my point.
Madam Hearing Officer, NMED is bringing up allegations from 2008, 2009, 2016, 2019, 2023, 2024, and 2025. And if I understand NMED to be arguing correctly, we are not allowed to question NMED regarding specific actions that NMED took against CRRUA in 2024 and impeach the credibility of Mr. Roderick, who made multiple statements of opinion on his direct examination in regards to his feelings about CRRUA and the enforcement efforts that NMED embarks upon, the role as the regulator of NMED to protect, and the role of NMED to comply with the regulations that it administers. And so to exclude evidence that goes directly to the credibility of that line of testimony that Mr. Roderick expanded upon numerous times is substantially unfairly prejudicial to CRRUA, as well as, I believe, reversible error.
And Madam Hearing Officer,
Yeah.
he's allowed to question Deputy Secretary Roderick about all of those things, that all of those compliance actions that we took What he's trying to do is question Deputy Secretary Roderick about something that has absolutely nothing to do with any of those actions. Those samples that he's trying to bring into evidence right now were not used in any of the enforcement actions, and they were not used in the calculation of the penalty. They were not used in 2008, 2009, 2016, 2019, 2023, 2024, or 2025. This is simply Mr. Trujillo trying to spin away from those legitimate ACOs, and he's trying to bring into evidence something that has nothing to do with any of it. And again, I object that it's irrelevant to the testimony you heard from Secretary Roderick.
Okay, so if that's true, how do you tie in the samples you're talking about to Mr. Roderick's testimony?
The samples tie into Mr. Roderick's testimony exactly how I've spoken multiple times, Madam Hearing Officer. Mr. Roderick testified extensively. He testified that he's an expert in requirements to comply with regulations. He testified that NMED has adopted the CFR, Code of Federal Regulations. He's testified that NMED is supposed to follow the Code of Federal Regulations. And so this line of questioning is not to seek samples into evidence. It's to impeach the witness in regards to his statement that NMED, he's an expert in the requirement to comply with regulations, that NMED is supposed to comply with regulations based upon these samples. And so I think what we want to do is we want to be part of the trial transcript. We want the Deputy Cabinet Secretary of NMED, who testified at length about NMED's duty as a regulator of water systems in New Mexico, to testify why NMED conducted arsenic sampling at 10 locations that did not qualify as sampling points pursuant to the monitoring requirements that govern.
Your Honor,
allow me to finish my argument, please.
But you're doing a speaking objection. You're bringing the evidence into.
No. This is legal argument.
You're testifying.
Hold on, Mr. Real. Mr. Real.
Thank you. I'm sorry.
This is legal argument. I'm making a legal argument.
Okay, and here's what my antenna are picking up is that you'd like to quiz the Deputy Secretary about requirements in the CFR that are not specifically relevant to the compliance orders in this matter. And I don't think he should be subject to that kind of examination. This is not, we're not quizzing him about the legal requirements of all of the drinking water regulations or of the CFRs. That's
No, I'm not
that's
quizzing
not
him
what
on
you're
what the requirements are. I'm quizzing him on setting the standard, the baseline standard for what the CFR requires, which NMED has conducted many compliance samples on CRRUA over the past year and a half. And so there's a compliance sample under the CFR, and then there's an entirely different set of unannounced samples that had nothing to do with the CFR, did not comply with the CFR, to which NMED has already admitted that it did not comply with the CFR. And so this witness who's testified that he's an expert in compliance with regulations is, and I believe was drinking water, who also testified he was drinking water bureau chief at the time that this took place. I think CRRUA is entitled to ask this witness about those tests, ask him what the thought process was, ask him why NMED did not comply with those tests. And I think that if you're seeking to exclude it on the basis that, again, NMED has never argued in any pleading whatsoever that past enforcement proceedings went into the civil penalty as set. The hearing officer allowed it. NMED is now seeking to, the hearing officer sounds like they're heading down the path of excluding testimony that would impeach the witness in my client's favor when it deals with arsenic, when it deals with samples, when it deals during the relevant time period of this administrative compliance order, March of 2024. I feel like that's an abuse of discretion.
Okay, so let me correct you on one thing. He's already said he was not the chief of the Drinking Water Bureau. He was the director of the Water Protection Division.
I apologize.
Okay, so Mr. Real, let's proceed with a question or two, and Mr. Roderick, if I don't know is the right answer, that's fine. If anybody has a different witness who's going to address the particular questions around a variety of samples, that's fine. Please just answer from your own knowledge, if you would, please. Go ahead, Mr. Trujillo.
Thank you. Mr. Roderick, so as I was stating, you are aware then that 40 CFR 141.23 only allows for arsenic sampling to be taken from each entry point to a water systems distribution system that is representative of each source after treatment.
That's correct.
And those are called sampling points then.
Yes,
And so you're aware that 40 CFR 141.23 does not provide for arsenic sampling to be taken at any location other than a sampling point.
that's correct.
And so you're aware that NMED conducted arsenic sampling within CRRUA's service area on March 15, 2024 at the following physical locations: 2401 Airport Road, Santa Teresa.
Your Honor, Madam Hearing Officer,
Mr. Trujillo, you really do need to slow down.
I
Mr. Rayan.
Madam Hearing Officer, I object. Again, he's asking the witness about something he didn't testify to and something he has no knowledge of. He's the deputy secretary. He's not somebody that is out there doing these samples. And again, those samples are completely irrelevant to what we're here to discuss today.
I heard you say that. Mr. Roderick, are these samples samples that you have personal knowledge of, or that you came to have knowledge of in doing your own job?
I am aware that the sampling took place, and I am aware of the reason that we initiated that sampling.
Okay, so I'm going to let Mr. Trujillo continue a little bit. Go ahead.
Thank you. So you're aware then that NMED conducted arsenic sampling within CRRUA's service area on March 15, 2024 at the following physical location: 2401 Airport Road, Santa Teresa; 1200 Futurity Drive, Sunland Park; 5805 McNutt Road, Suite F, Sunland Park; 5622 McNutt Road, Sunland Park; 5200 McNutt Road, Sunland Park; 5300 McNutt Road, Sunland Park; 5101 McNutt Road, Sunland Park; 3365 McNutt Road, Sunland Park; 3365 McNutt Road, Sunland Park; and 1673 McNutt Road, Sunland Park.
I believe that's correct.
And you're aware that none of the above mentioned physical locations is an entry point to respond to this distribution system as set forth in 40 CFR section 14123A1.
I am.
And you're aware that none of the 10 locations I just listed that NMED sampled were valid entry points where arsenic sampling could be conducted, correct?
That's correct. For compliance purposes.
So NMED then took it upon itself to conduct monitoring at invalid locations that did not comply with the Code of Federal Regulations that it's required to uphold them.
Objection, Your Honor. He's misstating what my witness
All
said.
right, Ms. Roderick, if you need to rephrase the question as part of your answer, please go ahead and do that. Go ahead.
I'm sorry, it's a yes or no question. I'm asking a leading question. I'm not asking an open-ended question.
Okay. Ms. Roderick, if you cannot answer the question in the way it was stated to you, again, provide an answer if you can that is responsive somehow.
Could I have the question again?
So NMED took it upon itself to conduct monitoring at invalid locations that did not comply with the Code of Federal Regulations that NMED is required to uphold, correct?
That is
Statement of
correct, but not for compliance purposes.
Out of those 10 invalid locations, only one resulted in an exceedance of the MCL, the maximum contaminant level. Is that correct?
That is my understanding.
And that location was the shower of the Love's truck stop on Airport Road. Is that correct?
I believe that is correct.
And so that sample from the Love's truck stop shower did not cause that arsenic treatment plant's running annual average to exceed the MCL. Is that correct?
That is correct. Again, those samples were not for compliance.
And that sample from the Love's truck stop shower did not create a violation of the arsenic standard then, right?
No.
Yet, are you aware that NMED issued a press release on March 28, 2024 with the headline, Camino Real Regional Utility Authority exceeds arsenic drinking water standard? You aware of that?
Your Honor, I'm going to object again to relevance.
All right, that's overruled. Go ahead, Ms. Roeder.
I don't recall specifically that press release.
You don't recall the press release?
I do not recall it.
Do you recall any press release regarding these unannounced samples?
I don't recall specifically any of those.
Would you like me to refresh your memory? Not an exhibit, this is just from the witness to refresh his memory.
Your Honor, may I review that before my client does?
Please.
Yes, sir.
You recall that press release now?
I do.
Had you seen it before?
Yes, I believe so.
That press release did not state that the sample that exceeded the arsenic drinking water standard came from the Love's truck stop shower, did it?
Yes, sir.
In fact, this press release did not state that the sample came from a location that is not a valid sampling point, did it?
I don't see that it did.
And you authorized the sampling at those invalid sampling points?
Objection, Your Honor, that's not what he testified to.
I'm asking.
Okay.
I did not personally authorize it.
Who did?
I believe that was the Drinking Water Bureau chief and potentially the secretary,
Okay, and the Drinking Water Bureau chief is
Joe Martinez.
Bill Martinez. Thank you. So based on this unannounced sampling of locations that were not valid sampling points under the Code of Federal Regulations that you enforced, NMED was able to publicize what NMED perceives to be CRRUA's bad acts, correct?
We did that public announcement.
Yes or no, please, first and next.
No, I would like him to provide the answer he'd like to provide. I think he's being cooperative with you, Mr. Rio. Go ahead, Mr.
And thank you. We do have the ability to publish that type of information. I think it's important to understand that the intent behind doing the additional sampling, which was not compliance related sampling, was to be able to assure the public that things were being done to protect them. As I testified to earlier, the public's trust in CRRUA has been all but completely eroded. And so the necessity to inform the public, the necessity to assure them that the water they're getting is safe was the reason behind that. It was not directed at their compliance, but it was hopefully going to confirm that, yes, they were getting things under control and were protecting the public.
Press release didn't say this is not compliance sampling, did it?
Not that I saw, but I don't write the press release.
And the press release didn't say this is not a violation, did it?
Not that I saw.
And the press release didn't say, hey, we took this from the tap of a Love's truck stop shower.
Does not indicate that.
And the press release did not say that under the CFR, CRRUA can only be tested at entry points that are designated in the CFR of its distribution system, did it?
It did not.
So the press release did not say this was not a valid sample under the Code of Federal Regulations that NMED purports to follow.
It did not.
What you're saying then is what you're saying is the NMED can pick and choose when it complies with the Code of Federal Regulations at its whim.
Objection, Your Honor. That's not what Secretary Roderick testified to. What he was saying is that there's compliance sampling, which is used to calculate, and there's non-compliance sampling. And these were non-compliance samples that were taken in order to reassure the public.
I heard all of that, Mr. Real. And the question was argumentative in its form. Mr. Roderick, do you have a response?
My response, I guess, would be that while the CFR identifies the compliance points that have to be utilized to determine compliance of a system, it does not limit the ability for sampling to be done at other points. But that information from those samples cannot be used to determine whether or not the system is compliant under the CFR.
So those sampling points are not, the samples that NMED took were not compliant with the CFR then?
Asked and answered.
That is asked and answered. Mr. Trujillo, please move on.
Sure. Mr. Roderick, where's the authority in the CFR to take those samples at the locations that they were taken?
Also asked and answered, Madam Secretary and Madam Hearing Officer. The Secretary testified that these were not samples taken under the CFR for the purposes of the CFR. They were not compliant samples.
Right, but the question now is, where's the authority to take samples that are not compliant samples?
So the CFR does not cover that, but the other regulations, the water protection regulations of the state of New Mexico authorize the Secretary to authorize additional efforts to be taken in situations where he feels they're necessary to protect the public health.
Thank you. So Alman, that testimony. So in this situation then, were you part of the discussions regarding those samples?
I was.
What you're saying then is that the Secretary in this instance authorized samples that were unannounced and that were not compliant with the CFR for the express purpose of what?
Ensuring the
Objection, Your Honor. This argument.
ensuring the protection of the public health.
Real?
It's argumentative, harassing, and has already been asked and answered. But we'll answer it.
I'm just trying to narrow down what his testimony is. It said that the Secretary has the authority to. What you're saying, that the Secretary has the authority to do what he did, which is to order unannounced, unauthorized samples that were from invalid location to the CFR. You're saying that he has that authority, correct?
Objection, Your Honor.
He did say that.
Okay.
Yeah, asked and answered.
And you're saying he did that for the express purpose of what? To protect public health?
Determining the protection of public health.
So determining the protection of public health to when 1 out of those 10 samples exceeds the arsenic standard and does not result in the running annual average to be violated, does not constitute a violation. How is that protecting the public health? Let me ask you this. I'm sorry, I'll withdraw the question. What's the point of the running annual average as the Deputy Cabinet Secretary for NMED? What is the point?
Objection, Your Honor.
Well, what is the point? What is the meaning of it in the context of how you regulate drinking water systems?
I withdraw the question. What is the purpose of a running annual average in regards to determining compliance of any contaminant in the water supply?
The running annual average was established as the mechanism for compliance by US EPA. And would indicate that so long as the average over a 12-month period does not exceed the arsenic level, that there's a reasonable expectation of the public being protected.
So if the running annual average does not exceed the MCL for a particular period, the public health is protected. Is that correct?
You're,
I'm trying to understand I'm not trying to reframe. I'm trying to follow the testimony.
what I'm going to object to is that the secretary has already testified that the running annual average is based on compliance samples. And again, these are irrelevant to that. These are non-compliance samples that were taken for non-compliance reasons.
Yeah, we need to keep that distinction, I think, through the.
I'm just asking about the running annual average. That's what I'm asking about. I'm asking about the running annual average.
But again, Your Honor, that's irrelevant. These samples are relevant to the running annual average. They're not used to calculate the running annual average.
So I believe that he's moved to a different topic. We're not talking about the samples for purposes of this question. Is that true, Mr. Trujillo?
Well, we jump back and forth, but for now, I'd like to understand the witness's perception of the purpose of the running annual average as a stated cabinet secretary for the department that is empowered to regulate drinking water systems through the state of New Mexico. What that understanding of the running annual average is and why it exists. And what I believe he testified is that if a running annual average is established that does not exceed the MCL, that the public health is assured. Is that correct?
Your Honor, real quickly, he's attempting to confuse the witness by jumping back and forth between relevant testimony and irrelevant testimony, between the CFR, non-CFR, compliance samples, non-compliance samples. He needs to pick a topic, finish it, and move on to the next one.
All right. So here's my concern. You had already constrained effectively through your objections Mr. Roderick's testimony as to kind of the science of protecting public health as opposed to regulatory authority to protect public health. And I think the question that's pending now drags us back into the scientific expertise or the public health expertise.
I'm not trying to go there,
Okay.
Madam Hearing Officer. What I'm trying to ask is, why is it important to comply with the running annual average?
Okay.
The importance of requiring with the running annual average is that has been established by the US EPA as a protective level to the public with regard to consumption of arsenic in drinking water.
Protective what? I'm sorry.
A protective.
I'm hard of hearing. I'm sorry.
The 12-month average is used to establish compliance with the protective level established by the US EPA of 10 parts per billion.
Protective level. Thank you. So protective level. Would you also agree that the RAA allows a public water system to address glitches in the system as they may arise? Is that correct?
Yes.
Now, you testified that there's a pattern of CRRUA falling out of compliance, coming into compliance, and falling out of compliance. Is that correct?
Yes.
And am I to understand you that based upon that previous pattern, NMED believes that CRRUA should receive a bad faith enhancement on its civil penalty.
Objection, Your Honor. That's not what he testified to. He's asking to speculate. What he's testifying to is that based on the fact that they have come into compliance, gone out of compliance, he testified that based on the acts that they have already committed, they are entitled to the bad faith enhancement. He's asking to speculate as to in the future whether or not that's going to be part of it. And that's not part of the calculus.
That's not what I'm asking.
Phrase.
I'm not asking what I'm asking is, believe he testified that CRRUA has had a pattern of coming into compliance, falling out of compliance, coming into compliance, falling out of compliance. And what I heard him say is that if he didn't say it, then he can testify to that effect. What I heard him say is that that goes into the assessment of the civil penalty against CRRUA. And I'm trying to understand how.
Your Honor, that's already been asked and answered by the Secretary. We're allowed to rely on previous bad acts.
Okay, so I did hear him testify now. Mr. Trujillo is asking to explore that. I think that's fine. Go ahead, Mr.
So an awareness of the prior history is obviously important in determining what may or may not happen moving forward. But the ACO that we're talking about here and the penalties is exclusive to the fact that CRRUA, and I'm saying CRRUA as an organization, intentionally put systems offline that had to be operational to protect their customers, and intentionally failed to report that or notify their customers. That is the sole basis of why we are here today. And the issue becomes management of the system, decisions like that intentionally put the public at risk. That is unacceptable behavior. There is no excuse for that kind of behavior. There's no justification for that. The concept that and it's unfortunate that the Safe Drinking Water Act sets compliance on a 12-month rolling average that allows you to be out of compliance for a period of time and then come back in and you're good over the 12 months. Because it doesn't address the impact that potentially is happening to the public who's consuming that water, who has children or grandchildren or older citizens that are drinking water that is not safe. All right. And we can split hairs about, well, it was just a spike here or there. But CRRUA has an obligation to protect its customers. And we're here today because they did not do that.
Thank you. Deputy Cabinet Secretary, I want to go back to what you said, which is you said that the sole basis for the civil penalty are the actions with the bypassing of the arsenic treatment systems and the failure to notify the public. And so what I'm trying to understand is your testimony in regards to the pattern of non-compliance and coming into compliance and pattern of coming back into compliance and only addressing things when they're caught. So that testimony, according to what you just said, has no basis on the civil penalty. Is that right?
Your Honor, that mischaracterizes what the Secretary testified to earlier, which was that we are entitled to look at previous bad acts and previous patterns of practices and in order to assess these penalties and the bad faith enhancement.
Okay, thank you for that. Mr. Trio, again, just rephrase it a little bit to make it clear.
What I'm asking him is how this pattern plays into the civil penalty. Can you explain how this pattern plays into the civil penalty? Because what you just testified was that the sole reason we're here is for these specific acts. So how does that pattern play into the civil penalty?
Well, I think, as I testified earlier, we have this history, and there has not been an effective way to get long-term compliance with CRRUA. We have not been able to break the cycle. And that's, yes, that's an issue, right? We haven't been able to break that cycle. What we've done before hasn't worked. We stepped up the enforcement approach based on this current activity, but understanding that what we've done prior has not been effective.
Thank you.
And also understanding that some of the people that are currently operating CRRUA right now and are in management positions were around during those other time periods.
Understood. So that's where I wanted to, that's what I wanted to understand, because what I hear you saying is that there's a history of non-compliance and compliance that has led up to this moment. Is that correct? A history?
Yeah, there's history.
And so I think what you testified to in regards to the ERG report, you're familiar with that report,
Yes.
right? So I believe you testified to the ERG report that CRRUA didn't have standard operating procedures. Is that right?
That's what they determined.
So CRRUA didn't have operating procedures in 2016.
Not that I'm aware of. I don't have
CRRUA didn't have
knowledge.
CRRUA didn't have standard operating procedures in 2009.
Not that I have any knowledge of.
CRRUA has standard operating procedures today. Is that correct?
They do.
So you'd agree that the standard operating procedures were approved by NMED, were they not?
That they currently have?
Yes. So those standard operating procedures approved by NMED help keep CRRUA in compliance, do they not?
That is correct.
So there's one thing that CRRUA has today that it didn't have in 2023, 2019, 2016, or 2008. Is that correct?
That's correct.
And so when you talk about the cycle of non-compliance and compliance, you're not factoring in that there's standard operating procedures in place that would prevent those types of reoccurrences, are you?
Objection, Madam Hearing Officer, that's not what he testified to.
I think it's a good question. Is he factoring in the fact that the SOPs exist now?
Right, but what he testified earlier was that there were many things that went into his
I understand.
and the fact that they've done one thing at this point.
I understand that would be a perfectly good response from Mr. Roderick.
Okay, thank you.
And then if we could break for lunch, Mr. Trujillo, let's get this answer
Oh, I'm
and
sorry.
then break for lunch.
Let me respond to that. I acknowledge that CRRUA has now developed SOPs in response to the action taken by NMED, in response to the comprehensive report that we paid for, that we initiated to have done. It was reactive, which is historic CRRUA. It was not proactive. I have not seen proactive actions on the part of CRRUA outside of what was brought to their attention through that comprehensive performance evaluation. So does that factor in? Well, yeah, we appreciate the fact that they've done that, but they did that after direction, after intervention by NMED, not prior to it, not voluntarily. I'm assuming that their management team was aware that they should have had SOPs all along and didn't. And so to give credit to the fact that now they're suddenly doing what they got to do to meet some of those requirements to help them get into compliance and to be able to maintain that and operate correctly, that's a great thing. But it's, again, after the fact. It didn't happen, and I see no indication that it would have happened had we not brought it to their attention.
Can we break for lunch now, Mr. Trio? All right. Thank you all. We are breaking for lunch. It is noon. We'll return at 1. At 1, I will invite public comment. You can go once for up to 3 minutes. And then we'll return to Mr. Roderick's cross-examination by Mr. Trujillo. Thank you. Good afternoon. My name is Felicia Orth, hearing officer appointed by the Cabinet Secretary to conduct a hearing in the Water Protection Division CRRUA case, docket is DWB 2413, pursuant to a hearing order and notice of hearing entered earlier in this proceeding. It was agreed that public comment would be invited at 1 p.m. So let me ask first if there's anyone in the room who would like to offer public comment. All right, there will be other opportunities. Luis has said that there were some folks online who would like to offer public comment. Luis, would you unmute them, please?
Yes. Community in Sunland Park, if you would unmute yourself. Thank you.
Number of folks in a classroom we've set up here in Sunland Park. And I'm having a little bit of a hard time hearing you. We just have one little laptop. So if it's okay with the court, could we just have them one at a time offer their public comment?
Yes, just a few things. One, I do need folks to understand that they can speak once. They can speak for up to 3 minutes. And I need them to state and spell their first and last name before they begin their comment. And I won't count the stating and spelling of their first and last name against their 3 minutes.
If any member of the community feels uncomfortable sharing their full name, is it okay if they share just their first name?
That's fine. That's how it will be reflected on the transcript. The other thing, though, is that I will need them to pause after they state their name so that I can ask them if they swear or affirm to tell the truth.
Okay, we'll get started now.
Thank you very much.
Are you going to speak as well?
Madam Hearing Officer, for the record, I renew the objection for the public comment portion. And I would also like to point out that not only is this not purely public comment, but I believe that you have an attorney who's present in the public comment, actually advising those individuals prior to their public comment. And that individual is currently representing specific plaintiffs in a lawsuit against CRRUA. So not only is it unfairly prejudicial, but now you almost have parties who may be testifying public comment who have not formally intervened in this matter. It's just an objection for the record.
All right, your objection is noted. Please go ahead.
Can I just have everyone keep it down, please? Shh. Go ahead, sir.
Okay, so if you want to state your first and last name and spell it out for them. Right here on the audio, you're already recording. Just go ahead and start speaking.
My name is Gordon Bunge.
As loud as you can.
B-U-N-G-E.
Do you swear or affirm to tell the truth?
Yes.
Thank you. I'll start your 3 minutes.
And you can go ahead and speak. Say where you live, how long you've been custody.
We've been lived in Santa Teresa 34 years. We built our house. Right on the border.
Sir, I'm sorry. It's hard to understand your words. I'm very sorry.
Why? Tell them why.
I have a problem with that because I have Parkinson's disease.
Oh, I was able to understand that. Thank you. If you would just speak each of your words as clearly as possible, we're making a transcript.
And had the suspicion that it was probably due to the water, but we don't know. I'm a retired chemistry teacher after 31 years in the public schools. Well, this is not too far-fetched from my understanding. You can see the result of the Parkinson's disease. I have trouble speaking. My wife, we can go ahead.
You're done?
Yeah.
Okay.
Thank you very much, sir.
Where's the judge? I don't see it. Okay, one moment. Okay. Judge, can you hear me?
Yes, I can very clearly.
Wonderful. My name is Maria. The last name is Bungie, B as in boy, U-N-G-E, Bungie. My husband just spoke to you. He has
Yes.
Parkinson's disease.
Thank you. Do you swear or, ma'am, hold on. Do you swear
Yes.
or affirm to tell the truth?
Absolutely, yes, ma'am.
Thank you. Go ahead.
Okay, my husband is the one who just spoke to you. We've been in the area in Santa Teresa for 31 years. We built our house there. And shortly after, we started getting letters from CRRUA that there was arsenic in the water. So immediately we went to buying bottles of water. So every day we go out to buy bottles of water or one of the dispensaries that sells the water. And shortly after that, my husband was diagnosed with Parkinson's. I have now thyroid disease. And of course, we attribute it to the arsenic in the water. As far as situation with the rest of CRRUA, you better be on time to pay your bill. Or if you're one day late, you have to pay an extra $5, which we think is unreasonable. But mostly it's the physical ailments that are of a concern. And then we plan when my husband and I die. He's 80 years old. He just turned 80. I am 75. And we plan for when we die, we will leave our home to our son, our only son. And of course, we would like for him to have clean water for his children. And that's all, unless you have more questions for me.
No, thank you very much, Ms. Bungie.
Thank you. God bless you. Thank you.
I have the next one's coming. And we're just switching right now, Judge. We're getting the next ones on the line.
Thank you.
You want to go ahead and state your first and last name, spell it out for them, and then just pause. That way the judge can ask you a question, okay?
Okay, it's Alma Alvarado, A-L-M-A, Alvarado, A-L-V-R-A-D-O.
And do you swear or affirm to tell the truth?
Yes.
Thank you. I'll start your time.
You can go ahead and tell them where you live, how long
Okay.
you've been affected, anything else you wanted to specify.
I live at 219 Mesa Verde at Sunland Park, New Mexico. I lived there most of my life since I was 8. Yeah, the water has affected me. I started getting sick. I had no clue what it was. I have an autoimmune disease, has affected me throughout different parts of my body. We had to get a water filter because the water was just so bad. We also have to buy bottled water. And it's very frustrating.
Oops, sorry. Thank you, Ms. Alvarado.
Is that it?
Yes, thank you very much for your statement.
If you want to state your first, last name, spell it out for the judge, and then just give a brief pause. That way she can ask you a question and you can start.
Okay. Hi, my name is Julian Alvarado, Julian Alvarado.
Do you swear or affirm to tell the truth?
Yes, ma'am.
Thank you. I'll start your time.
Well, I've lived in Sunland Park for I'm going on 65 years now. I'm the baby out of 8 in my family, and I'm the worst off out of all my brothers and sisters with a heart attack. Actually, I've had 2 heart attacks, and my brothers and sisters are a lot better than I am, me being the baby. I don't know, it could be the water, I'm not sure, but I've been here for 65 years now. On December 20th, it's my birthday. Since I was born, I lived here.
Thank you, Mr. Alvarado.
Okay, thank you.
Mr. Luca? You want to go ahead?
All right.
If you want to say your first and last name, split for the judge, and then give her a brief moment so she can ask you a question, and then you can begin.
Okay. My name is Raul Hernandez. Can you hear?
Yeah, just speak a little.
Raul Hernandez.
Spell your first name.
It's R-A-U-L Hernandez.
Okay. Do you swear or affirm to tell the truth?
Yes.
Thank you. I'll start your time.
And you can discuss how it's affected you, where you live, how long you've lived there, anything you'd like to tell them.
I've been living there for practically most of my life, and it's affected me from all my arms and my legs and my prostate. I have an enlarged prostate. I have asthma. I have an arrhythmia heart. I'm a diabetic. I have a neuropathy. So I have a number of sickness.
Okay. Thank you very much, Mr. Hernandez.
Anything else that you can go ahead?
Thank you.
Mr. Luckett, if you want to state your first and last name, spell it out for the judge, and then give her a brief moment so she can ask you a question.
Good afternoon, Judge. My name is Jesus Baquera, and I have
Would you
been
spell
living here.
that? I'm sorry. Would you spell that, please?
First name is J-E-S-U-S. Last name is B-A-Q-U-E-R-A.
And she's going to ask you a question.
Okay. Do you swear or affirm to tell the truth?
Yes, Judge.
Thank you very much. Go ahead.
Well, ma'am, first of all, I want to thank the lawyers involved with this case, as we have not been, nobody has been listening to us. Apparently, well, we have a whole bunch of water issues, ma'am. All that is affecting my community and myself in a very adverse way. I mean, I've lost my mother-in-law to cancer. 3 of my brothers-in-laws have cancer. Well, ma'am, I have an enlarged prostate. I contributed to the water, ma'am. This water is not good for consumption, and well, we need help over here, ma'am. Apparently, our city council is involved with the water department and are defending the water provider more than they're defending its constituents. And I think that alone should be enough cause to do something about it. I'm hoping you will. Well, ma'am, and thank you. Thank you for listening.
Thank you very much, Mr. Barrier.
Thank you, ma'am. Bye-bye.
Ready? Alrighty. If you want to state your first and last name, spell it out for the judge, and then give her a brief moment so she can ask you a question.
Okay. Hello, my name is Fidel Briones. First name is F-I-D-E-L. Last name is B-R-I-O-N-E-S.
And Ms. Brianna, do you swear or affirm to tell the truth?
Yes, I do.
Thank you. I'll start your time.
Okay. Well, I just want to say that, first of all, my wife and I moved into Santa Teresa about 7.5 years ago. We had heard stories about the water quality being really bad here in the Santa Teresa Sunland Park area, but we didn't think it was that bad until we actually moved down here, and we went straight to the office of CRRUA to try to get some information from CRRUA directly, which was not an easy thing to do. It seemed like we were always getting the runaround when we went down to the office. We couldn't get any information on the testing for a long time. They would tell us, we don't have any information right now. We requested to speak to the director of CRRUA, and that was another issue also. It was always like, he's not here right now, he's out someplace. we finally got to talk to him in person after quite a bit of persistence, and he pretty much assured us that it was a problem that would be taken care of shortly, and that our area wasn't being affected that much, really. And I asked for information on something in print as to their testing, and we got something in print that was done like about a year before. That was the latest information that was given to us. And I think it's disgusting that we're sitting here talking about this issue at this point in time. 7.5 years ago, we were here and we were told this issue would be taken care of. We hear people in Santa Teresa, Sunland Park area have had this issue for years and years and years, and nobody's done anything about it. It took a lot of publicity, then the media to come down here and talk about the issue. The lawyers got involved. The environmental department came down to Sunland Park at one of the meetings, and I asked them point blank, what took you so long to get here? I never really got an answer as to why they took so long to get to the meeting down here. I think if this area was a wealthier community, maybe lighter shade of skin color, we wouldn't be here talking about this issue today. The water has been on and off. It's been dirty. It's been yellowish. It's been oily. At one point, we were told not to drink the water, not to wash dishes with water. And we were told that by the media. I mean, CRRUA did not reach out to us and tell us, stay away from the water. We found out about it because we came from El Paso, turned on the news, and that's what we found out about it, stay away from the water. And who knows how long we have been drinking this dirty, tainted water. And I just want to say that hopefully something good will come out of this. This issue will be resolved because it's been years in the making. And CRRUA has been dragging their feet. They haven't really done anything. They haven't alerted people when they have had issues regarding staying away from the water. They could have called customers. They have their phone numbers. Why couldn't they do a robocall and tell customers, oh, don't drink the water. We're having an issue. It's bad right now. People were still drinking that water, taking baths in that water, feeding their babies formula with that water. So I just want to say that hopefully something positive will come out of this issue.
Thank you very much, Mr. Brianis.
Thank you, Judge.
All right, if you want to state your first and last name, spell it out for the judge, and then just give her a brief moment so she can ask you a question, okay? Okay.
My name is Maria Elena Lucero, MARIALUCERO.
Do you swear or affirm to tell the truth?
I do.
Thank you very much. I'll start your time.
Okay, I've lived here since 1952. I've been here 52 years, and we've been having trouble with water all this time. And every time I wash my clothes, it comes out dirtier, so I have to wash it like 2-3 times. And then my skin has bumps all over the place. I have been to the dermatologist, and yet, where I live, the water leaks out and it's all full of poop, and it stinks. I can't be outside of my house because all I smell is poop. And I don't really know what to do anymore. I called CRRUA, they don't go to the house. And if by chance they ever do, I'm gonna let them have it because I'm tired of this. It's affecting my life, my husband, my kids. Even though they don't wanna do anything, I do wanna do it because I wanna do it for the people because I've been here all my life.
Thank you very much, ma'am.
Okay, thank you.
You want to have a seat. If you want to state your first and last name, spell it out, and then give a brief moment so the judge can ask you a question. You can go ahead.
Hi, my name is Mario Alberto Mora, M-A-R-I-O, Alberto, A-L-B-E-R-T-O, last name Mora, M-O-R-A.
Thank you. Do you swear or affirm to tell the truth?
Yes, I do.
I'll start your time.
Yes, I've been a resident of Santa Teresa for 40 years, And my experience with CRRUA as a utility company has been very disappointing. I believe that everybody in the United States should have clean water. That's just the basics. And as you heard it all, we don't have very good water. We have to purchase our own water. And in my neighborhood where I live, which is right across the water treatment plant, almost every year we have the pipes. They're corroded. They just here and there, they're always erupting, causing a shutdown in our neighborhood. So we don't have no water to wash, to bathe. And in the summers, just last week, right on my street, one of the lines busted. So I don't have no water from my swamp coolers. You know, and I'm sure there's a lot of old senior citizens that live in my block, and we all have swamp coolers, and without that water, I mean, it is very, very hot. And some of us older senior citizens are just really suffering out there. So we need water. And thank you for doing what you're doing, and I hope we could get this fixed. Thank you.
Thank you, Mr. Mora.
You want to state your first and last name, spell it out, and then give a brief moment for them to get asked the question.
My name is Irene Rodriguez, IRENE Rodriguez, RODRIGUEZ.
Thank you. Do you swear or affirm to tell the truth?
Yes, I do.
Thank you. I'll start your time.
Do I start now? Okay, I was raised and born here since 1961. Before we had our salitre water, but now we have arsenic, and the water's not getting any better. It's getting worse. And we knew about this problem. We kept going, talking to people, and all they had is just complaints. We did go to the city hall meetings, to CRRUA's meetings, and to the county's meetings. They wouldn't listen to us. We were asking desperately somebody to help us. We went and asked for signatures. We had the signatures of all people from the residents, but nobody would listen to us. And I'm very, very thankful for Israel Chavez and all his lawyers that they listened to us. We were desperately, and yet people are still, they saying they're not going to do anything. Nothing has been done over and over the years. But you know what? These gentlemen are working very hard. They communicate with us. They tell us what's going on. And I'm very grateful that we have these people to help us out, because nobody would help us out. Not the mayor, not the county, not the CRRUA. And we went to all the meetings. So I'm very grateful that they're helping us. And please take that in consideration. Thank you.
Thank you very much, Ms. Rodriguez.
Your Honor, we have an interpreter here. The interpreter was inquiring if those who are speaking Spanish and interpreting, if they could have a little extra time, or how that was going to be handled.
Certainly, sir. I would like the name of the interpreter first.
Yes, this is the voice of the interpreter. I don't know if you can see me, but
I can.
I'm a certified interpreter in the Spanish language.
And
my name is Juan Ramirez.
And Mr. Ramirez, do you swear to faithfully interpret between English and Spanish?
I do.
Thank you very much. So now, yes, if I could have the name and spelling of the folks you'll be interpreting for.
Comience con decir su nombre y apellido y luego el de la señora también.
Mi nombre es José Antonio Loya y voy a hablar por el Socorro Ramírez, que vive en 129 Roble desde hace 22 años.
The person speaking is Jose Antonio Loya, and I will be speaking on behalf of Socorro Ramirez, who resides at 129 Robles. She has lived there for 22 years.
All right, thank you. And do you swear or affirm to tell the truth?
Señor Loya, si levanta su mano derecha, ¿afirma o jura usted de que va a estar diciendo la verdad?
Thank you very much.
Sí,
I do, yes.
I do.
Puede bajar. Muy bien.
Thank you. Please go ahead with your statement.
Prosiga con lo que iba a decir.
En la casa de donde vive Socorro y mi hijo, yo vivo en El Paso, Texas, pero tengo conociendo lo que han pasado ellos por todo el tiempo desde que está CRRUA con el servicio de agua, que ha sido andar comprando agua porque el agua de la ciudad no está buena.
All the time that Socorro has been living there at the house, along with my son, as I live in El Paso, Texas, I've been aware this whole time of what's been going on with CRRUA and the water service there, and how they've had to be buying water all the time because it's not any good.
Socorro tiene un año, va a ser un año, 2 meses que tuvo que ser operada de cáncer en la matriz. Es consecuencia, decimos, por el agua que está tomando.
Socorro, it was 1 year and 2 months ago that she had to have cancer surgery.
1 year and 2
1 year and 2 months ago. She
had surgery.
She had surgery on her uterus, and we say it's because of the water.
The cancer.
She had cancer.
¿Sí? Es el problema desde que está CRRUA, que no ha habido un buen servicio, muy buenos cobros, pero no buen servicio. Siempre cuando va uno a quejarse, a decirles algo, nunca tiene uno la razón. Ellos siempre quieren ganar.
The problem has been ever since CRRUA has been there, that with them, they're good when it comes to billing, but when it comes to service, they are not. If you have a complaint, you come to them, they're always the ones that are in the right.
Okay. ¿Está bien?
Along with Mrs. Ramirez here beside him, she's indicating, yes, that's fine, and that's all.
Thank you very much to Ms. Ramirez, Mr. Loya, and Mr. Ramirez. Thank you.
Thank you.
Gracias a ustedes, señora juez, es todo. Gracias.
You want to state your first and last name?
Sí.
Spell it out for her, and then give her a moment so she can ask you a question, okay?
Tiene que dar su primer nombre, su apellido y deletrearlo y luego lo
Si quieres esperar.
No,
Van a ser juntos.
Sí.
Okay. Sus nombres.
Si pueden dar su nombre, por favor, nombre y apellido y función.
Mi nombre es Gilberto Iglesias y María Iglesias.
My name is Gilberto Iglesias and Maria Iglesias.
All right, ma'am, the interpreter, if you would state and spell your own name, please.
Yes, good afternoon. My name is Nancy Gorman. First name is Nancy. Last name is Gorman. I'm a court certified Spanish language interpreter.
And Ms. Gorman, do you swear to faithfully interpret between English and Spanish and English?
I do.
Thank you very much.
You're welcome.
And do the Iglesias swear or affirm to tell the truth?
¿Ustedes juran o
Sí,
afirman que van a decir la verdad?
Juramos decir la verdad.
Yes, we swear that we're going to tell the truth.
Thank you. Please proceed.
Nosotros llegamos a Sunland Park en el 2004
We arrived in Sunland Park in 2004.
y nosotros no sabíamos nada de esto del agua y tomamos agua y nos bañamos, hicimos comida y todo con esa agua.
And so we didn't know anything about the water, and so we went ahead and drank the water, and we also bathed ourselves in the water, and we also cooked and made food with the water. We didn't know anything.
Entonces en el 2007 a mí me dio un infarto que yo pienso que es por el arsénico que hemos estado consumiendo. Y después de allí a mí me resultó diabetes y algunas otras enfermedades, hipertensia y todo eso.
And so in 2007, I had a heart attack. And what I think is that it's due to the arsenic that we've been consuming. I have also gotten diabetes, and I have gotten other illnesses and hypertension as well.
Se nos ha echado a perder muchos aparatos como los aires acondicionados, el boiler, los refrigerador y la lavadora por el salitre que tiene el agua, las tuberías se tapan y todo eso es reparación y gastos de uno que tiene que hacer.
And so we've had quite a few appliances that have broken down, and like the air conditioning, also the boiler and the refrigerator, the washing machine. And I believe it's because of that salt that is in the water. And also we've had problems with the pipes. The water pipes have been blocked. And what that means for us is that we have to pay for the repair and the expenses of fixing them.
Y la CRRUA sigue subiendo el agua, subiendo que para mejorar la calidad y nunca lo ha hecho. Sigue igual la agua y nosotros tenemos que comprar agua aparte y es un gasto semanal tener que comprar de 3 a 4 galones de 5 galones por semana.
And so CRRUA, what they've done is that they keep increasing the price of the water, but the quality has not improved. And what ends up happening, the water has just been the same, so we have to end up buying the water, and it's a weekly expense. We have to buy 5-gallon bottles, and we have to buy about 3 to 4 per week.
Y eso es todo.
And that's all.
Thank you very much, Ms. Gorman and Mr. and Mrs. Iglesias.
Muchas gracias, señor Gorman y señor Iglesias. Okay. Thank you.
And this witness is also using the services of interpreter Juan Ramirez.
All right, thank you very much. If I can have the statement and spelling of her first and last name.
Comience con decir su nombre y apellido, por favor, y lo deletrea.
Mi nombre es Dolores Rodríguez.
Escribe D-O-L-O-R-E-S y Rodríguez, R-O-D-R-I-G-U-E-Z.
Sí.
My name is Dolores Rodriguez, D-O-L-O-R-E-S, capital R-O-D-R-I-G-U-E-Z.
Thank you. Does Ms. Rodriguez swear or affirm to tell the truth?
Levante su mano derecha que si usted afirma o jura decir la verdad.
Sí.
Yes.
Thank you. Please proceed.
Pues baje su mano y proceda con su testimonio, por favor.
Bueno, pues mi testimonio es igual. La agua muy cara, mala calidad.
¿Dónde vive?
Vivo en Sunland Park.
Okay, my testimony is the same, is that water is very bad and it's very expensive. I live in Sunland Park. ¿Quiere decir algo más?
Sí. Que el agua está pues muy alto, los cobros y lo mismo. Se le echan a uno a perder sus aparatos electrodomésticos porque por el agua salitrosa, los baños, todo se echa a perder. y gastos extras para uno. El agua sube cada día y va uno y les dice, ¿por qué no? Ya subió y pues no le contestan. Es muy groseras de que casi lo echan uno para afuera porque quiere saber cuál es el motivo que está subiendo el agua cada vez más alto y más alto.
And the same for me, that my home appliances get ruined also, just the same because of the amount of salty residue in the water, and that the cost of the water continue to be very high. The bills are very high. They almost go up daily. You go in, and if you complain and you talk to them, they don't say anything to you. They do not explain. They're rude with you. They almost kick you out when all you're asking is, why is the water cost going up so much? We just want to find out.
Y pues también compro agua cada semana, bastante, como 5 garrafones y aparte botellas de galones para poder cocinar y tomar agua, porque no podemos tomar el agua. Me salió en un tiempo blanca con mucha espuma, después como amarilla. Y uno pregunta y no le dan razón, nunca saben nada ellas. Entonces espero que hagan algo al respecto porque es mucho ya lo que uno está batallando aquí y gaste dinero que uno no tiene. Y pues eso es todo, espero que hagan algo.
Me too. I'm having to buy water as well. The 5-gallon containers, about 5 of those a week, plus gallons, single gallons of water in order to cook and to drink, because you can't drink this water the way it's been. For a time, the water used to be white and with foam on it. And then for a time, it was yellowish. You go in and you ask them to explain, they don't explain anything to you. And so I hope that you are able to do something about it, because here we're just having to battle with them. We struggle with this, and it all costs money, which we don't have. So I hope you get to do something soon. That's all. Yes, sir.
Thank you very much, Ms. Rodriguez and Mr. Ramirez.
Yes.
Gracias.
He speaks English, but let's see what it. Yeah. ¿Quieres intérprete en inglés? ¿En inglés? Fácil. 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 Gracias.
You want to state your first and last name, spell it out for the judge, and then give her a brief moment so she can ask you a question.
Okay. Can I start right now?
Yes, go ahead.
Hello, my name is Hector Ortega, and my wife's name is Anita Ortega. She's not present, but there's only 2 people living in Sunland Park, 118 Roble, and we've been there for over
Hold
15.
on, Mr. Ortega, just a moment. Do you swear or affirm to tell the truth?
Yeah.
Okay, please
I'd say
go ahead.
Okay, and we've been living in this house for over 15 years, and ever since I know that this water is being contaminated, and then last year started to come out dirty, very dirty water, and we don't know if sometimes it's been dirty too, but this time it was so dirty that we start noticing that it was coming so dirty, and then it's so expensive. We pay $120 a month, and it's that is too much money because we don't have any trees. We don't irrigate anything. We don't use it for anything but for shower, and we don't use it for cooking because of the problem that is not drinkable, and you know, it's so expensive. And when you go over there, I went twice already, and I asked them to check my meter, and they said, okay, give us a time. And then I didn't see anybody going to check my meter. They just when I go and check with them again, they tell me they went to check your meter and it was okay. And I don't know. My daughter lives in Lower Valley, and they have a wonderful water. I mean, you can drink and feel confident that you're drinking good water. I don't know what the deal is. And then over there in my daughter's house is there 6 pay $40, including the trash, $40 a month. I understand that this is New Mexico, but the difference is so big. And then when you ask your neighbors how much they pay, some of them, there are 5 people living in the house and they pay $40, they pay $50. I don't understand what the problem is with me paying $120 and they don't care about it. I think that is it. I would like to pay less for better water, and that is about it.
Thank you, Mr. Ortega.
Thank you.
That's everybody who was able to make it today. We just set up a computer because a lot of folks said they didn't have the ability to log in, Judge. So
I appreciate that. Would you identify yourself, though? I'm sorry.
Israel Chavez. I live here in Doña Ana County.
Thank you so much.
Thanks, Judge.
Bye. All right.
Madam Hearing Officer?
Yes, Mr.
At this
Trujillo.
time, CRRUA moves to strike the public comment in its entirety. What just took place is that the Madam Hearing Officer allowed plaintiffs in a separate lawsuit who were prepped by and coached by counsel who identified himself as a resident of Doña Ana County and not as their legal counsel to testify with no opportunity for cross-examination, with no regard for relevancy, hearsay, authentication, foundation. You know, we've all been practicing a long time, and I don't think I've ever seen anything quite like that. Our legal system is based on rules, and there can be no doubt that such testimony violated my client's due process rights, the rules of evidence, and 20.1.5.1. And CRRUA believes that its inclusion will result in reversible error. You can't unring the bell. We move to strike.
Thank you, Mr. Trujillo. I do not grant that motion. Mr. Al, do you want to address it?
The only thing I have to say, Madam Hearing Officer, is that they all identified themselves as consumers from the CRRUA water system that live in the CRRUA district and that utilize full water. I think it's very clear that they have standing to give public comment in this hearing because they are all clearly affected as they're all users of that water.
Mm-hmm. So, Mr. Trujillo, let me offer this much. Public comment offered in hearings that I do for the Environment Department, Environmental Improvement Board, and the Water Quality Control Commission often include public comment in which folks who are not, for example, medical doctors or toxicologists, attribute certain ailments, for example, to something going on in the air or water. And obviously, without expert testimony on that point to make a linkage, their comment can't be accepted directly to prove that point. But I think what it did do was provide the face of the folks on the other side of the water line, the face of the folks who are taking water from this system, that there are humans on the other side. That's all. So
thank you, Madam Hearing Officer, for the clarification. We will note that the hearing officer believes that the public comment was impactful.
I think it's important to allow these folks to speak up. Again, even though I will fully acknowledge that what we don't have in front of us is expert medical testimony, for example.
And Madam Hearing Officer, I object to Mr. Trujillo putting thoughts into your head that you noted that the testimony was impactful on your decision making. I don't think that's appropriate.
Yeah. All right. So thank you both, and we'll move now to back to your cross-examination.
Madam Mayor, Officer,
Yes.
we had one more user on the platform that has
Oh,
hand up.
okay. I'm very sorry. I didn't see the raised hand. Thank you. Sir, let's see if you would be unmuted.
All right. Hello. My name is John Sunday.
How do you spell the last name?
It's Sunde. Sounds like the day.
All right. Thank you. Do you swear or affirm to tell the truth?
I do, Judge.
All right. I'll start your time.
Okay. My wife and I moved here in 2018. And we built a home in Santa Teresa. In that new home, we placed a water system on the advice of the builder, but had not really heard that there was a problem, or at least not the extent of it. I paid for that water system, and it just, it didn't work. Okay. I was getting water that smelled horrible. I always kept going to the bathroom to make sure that I wasn't getting, checking my traps and everything. So if the sewer gases were coming through and whatever, and everything was okay, I complained to the builder. He set me up with somebody to come out and verify the water system. And they said, well, the water here this system isn't good enough. So then I had to go through the problem of getting my money back from the builder, okay, on that water system. And we went without it for a while, buying bottled water and the like. And it would go on and off and on and off. We'd get messages through hearsay, basically, that the water was bad this week. You need to start buying water. And we'd use that for a while. And then we get a message that it was okay to drink the water, and then back and forth on that. So my wife has cancer, breast cancer, and I have heart disease and an embolized spleen. So we just can't deal with that. So we went out and bought another water system at the tune of $3,500 to combat this. And then every 6 months we need to put in another $600 or $700 on filters. And still, with all that, the water just is, when you wash your car, it's crap. It's when you put it in the sink, it's just not right. Okay. I think it was to take as long as it has to straighten this out is very irresponsible. People have been, we can't go without water. So what do we do? Just keep buying water from Walmart or whatever. That's about all I've got to say. Thank you so much for your time.
Thank you very much, Mr. Sunday.
Renew the motion to strike.
Okay, it's denied. Mr. Lopez, is there anyone else on the platform indicating a desire to offer public comment?
Not at this time, Madam Mayor, Officer.
Sorry?
Not at this time.
No. Okay, thank you. Did anyone else join us in the room during that time? All right, I will invite public comment at least once more. But for now, let's return to Mr. Trujillo's cross-examination of Deputy Secretary Roderick.
So Roderick, so you're familiar with the arsenic rule, correct?
Yes.
And the federal arsenic rule was enacted in 2001, lowering the MCL for arsenic in drinking water from 50 parts per billion to 10 parts per billion, correct?
Yes.
And under the federal rule as adopted by NMED, public water systems had to meet the new standard by January 23, 2006, correct?
I believe that's correct.
And CRRUA's wells are in an area with high levels of naturally occurring arsenic, correct?
Correct.
Would you agree that in order to comply with the new arsenic standard, CRRUA was required to build arsenic treatment plants to treat the groundwater from its wells in order to meet the new standard?
That's correct.
And NMED's exhibits 2 through 5, which you previously discussed with Mr. Rail, are administrative compliance orders issued in 2008 and 2009. Is that correct?
Correct.
And they each generally address compliance issues relating to the arsenic standard.
That's correct.
Right? And they were issued to Doña Ana County Utilities Border Region, Santa Teresa Industrial Park, Santa Teresa Water System, and the City of Sunland Park. Is that correct?
Correct.
And in 2009, these water operations were actually being operated by the county. Is that correct?
I believe so.
And so none of those compliance orders were actually issued to CRRUA, right?
That's correct.
And so it's fair to say that CRRUA inherited the pre-CRRUA administrative compliance orders, right?
I don't say that you could say they inherited them because they weren't issued to CRRUA. I do think it is important to note that the administrative compliance orders, as you said, were issued when Doña Ana County was operating the systems. And Doña Ana County is part of the board that operates CRRUA.
What I mean is that Doña Ana County is not named in these administrative compliance orders, is it?
No.
But CRRUA, so the pre-CRRUA administrative compliance orders were, instead of using the word inherited, let's say that they actually were transferred to CRRUA.
I don't even know that that is necessarily accurate.
Right. So if they didn't transfer to CRRUA, and if CRRUA didn't inherit them, then would it be more fair to say then that they pre-existed CRRUA, and when CRRUA took over, CRRUA assumed responsibility for them?
I think it is correct to say that when CRRUA took over those operations, they assumed responsibility for ensuring that the water generated from those operations was compliant.
In other words, those individual water systems pre-CRRUA all had their own issues prior to being consolidated under CRRUA.
That's correct.
Eight years later, in 2016, another compliance order was issued, this time to CRRUA, correct?
That's correct.
And this is NMED's Exhibit 6, correct? The matter of DWB 1615. Objection, Madam Hearing Officer. This is beyond the scope of my direct examination.
Isn't this one of the previous compliance orders that Mr. Roderick already addressed?
Not one of the ones that I asked him about.
Mr. Trio?
My recollection is that Mr. Rowell asked him about CRRUA's previous compliance, non-compliant history, as well as prior enforcement proceedings. I believe that Mr. Roderick did testify that in 2008, 2009, and 2016 that there were administrative compliance orders that were levied against CRRUA. I mean, I don't know if he went over the specific exhibit or not, but I didn't introduce the exhibit during my examination of Mr. Roderick. I only entered exhibits 2 through 5 with Deputy Secretary Roderick.
Okay, I see that 2016 DWB 1615 ACO was at least marked as Exhibit 6. I know you didn't offer it.
Right, I didn't offer that yet. So it's beyond the scope of my direct examination. I have another witness that's going to testify about that.
Oh, about that one. All right,
Yeah,
we're going to
we'll,
their
we'll,
witness.
we'll save it for that witness.
All right.
We'll save it for that witness. Sorry, just 1 second. Yeah, Bruce. We're not gonna linger on this. I just would like you to let you know that is accurate.
That is my digital signature.
Do you recall signing that document?
Yes,
Are you familiar with that document?
I am. It's been a while since I looked at it.
I'm not going to ask you any questions about. I'm just. Are you familiar with that document?
Yes,
You recall the substance of that document without reading it right now. You recall the general substance of the document, and you have no doubt that that is a true and accurate copy of the document that you signed.
it is.
I'm going to move on. Mr. Roderick, are you familiar with Tier 2 violations?
Yes,
Can you explain to us what a Tier 2 violation is under the CFR? Is that right?
should be under the CFR. Been a while. Tier 2 violations, while our threat to public health are not imminent threat,
Sorry,
immediately critical. I'm just paraphrasing.
immediately critical. I can show you. Would you like something to refresh your memory?
Yes, if you have it there.
Approach.
Sure.
So in the context of this, of the CFR, a Tier 2 violation corresponds to the type of public notice that is required to be given in response to it, correct?
Correct.
And so what is the response that is required to be given for a Tier 2 violation?
Under a Tier 2, they're required to respond and provide a public notice as soon as practical, but no later than 30 days after the system learns of the violation.
And is an exceedance of the arsenic standard a Tier 2 violation?
Yes,
An exceedance of the arsenic standard is a Tier 2 violation?
typically, yes.
Or is it that an exceedance of the running annual average of the MCL is a Tier 2 violation? Objection, Your Honor. I'm not sure that Deputy Secretary Roderick is familiar enough with this topic to be able to answer these questions.
All right, I think, Mr. Deputy Secretary, if you would speak up where the questions go beyond what you know or what you would have to refresh your memory on.
Okay. again, the issue of compliance, and I need to be very specific about this, that the requirements for compliance under the US EPA regulations, for example, the 10 parts per billion requirement for arsenic that's the ground floor level. All right, that is the least protective level that was established by the EPA, the minimum. And the argument can be made that if you don't exceed that 12-month rolling average, that you're not non-compliant, and that therefore you don't necessarily need to notify the public. But is that acting in the best interest of the public? I think the answer to that is no.
This wasn't a trick question. The question is an exceedance of the arsenic standard a tier 2 violation that would require public notice anytime before 30 days? Matt, officer, again, asked and answered. I don't think he's familiar enough with this section.
I think Ms. Roderick is sufficiently sophisticated to speak up then. If this goes beyond something that you can just say without doing some research, just say that.
Well, this is a question that I would prefer to refer to some of my technical staff that'll be speaking later, because I think it can be more definitive.
Sounds good.
Thank you.
And I know you mentioned that there's still some outstanding items from the 2023 sanitary survey, correct?
I believe that there are.
And you are familiar with the administrative compliance order in this matter?
I am.
And you are aware that the administrative compliance order required CRRUA to address 4 significant deficiencies from the sanitary survey of 2023, correct?
Yes.
It did not require resolution of all of the significant deficiencies in the sanitary survey. Is that correct?
The administrative compliance order does not.
Thank you. So those outstanding items that you testified about, those have no basis on the civil penalty for this administrative compliance order, do they?
No.
And NMED filed its administrative compliance order on March 1, 2024. Is that correct? If I represent to you, if I represent to you, do you have any reason to disbelieve that?
No.
And the initial civil penalty that NMED assessed in that administrative compliance order did not contain an enhancement or a reduction for good or bad faith, did it?
Not in the original order.
I'm sorry?
No.
And at the time that administrative compliance order was formulated and that civil penalty was assessed, NMED was aware of the intentional and egregious acts that you testified about in regards to that civil compliance order, that civil penalty.
Yes.
Right? At the time that NMED filed its administrative compliance order in this matter and had already assessed the civil penalty, NMED knew about those intentional and egregious acts per your testimony, but did not place them or did not reference them as a basis for a bad faith enhancement in that compliance order, did they?
That's correct.
So it wasn't then until the second amended administrative compliance order, which was filed on May 23rd, 2005, that NMED raised the issue of a bad faith enhancement for the first time. Is that correct?
I believe that's correct.
And as you sit there today, to the best of your knowledge, CRRUA is in compliance with the arsenic standard, isn't it?
I cannot speak to that because I have not seen the most recent results. I don't know where they're at today.
As of what are the most recent results that you're familiar with?
I would have to. I'm not exactly sure when the last quarterly sampling was done. I believe it was in the last couple of months.
If I represent to you that the last quarterly sampling was performed by NMED on July 1st, 2025, would you have any reason to disbelieve that?
No.
And are you familiar with the results of the July 1st, 2025 compliance sampling? If you're not, that's fine.
I'm not. I have not seen those.
But you do know, you are aware of the administrative compliance order in this matter. And so you do know that CRRUA was required to lower its RAA below the MCL by March 31st, 2025, correct?
Yes.
And you do know that CRRUA lowered that RAA by January 28th, 2025, correct?
Correct.
So you agree that CRRUA lowered its RAA 2 months earlier than it was actually required to by NMED, correct?
I believe that's correct.
And are you familiar with the test results that have been spoken about in regards to voluntary testing that CRRUA conducted on April 23rd, 2025 and May 6th, 2025? Are you familiar with that?
I have some knowledge of them, yes.
And what is your knowledge?
Again, voluntary sampling that was done by CRRUA to track their compliance to ensure that they were staying in compliance.
And you know that you would agree then that CRRUA's RAA for that treatment plant did not exceed the MCL for arsenic based on those test results.
I believe that's correct.
And you would also agree that those test results therefore didn't result in violations of the arsenic standard. Is that correct?
I believe that's correct.
So you would agree that NMED, for which you're the Deputy Cabinet Secretary, did not issue notices of violations for those.
That's correct.
And you would agree that CRRUA didn't intentionally try to exceed the arsenic standard in those tests, would you?
I would
object to Madam Hearing Officer Foundation.
Uh,
How was he supposed to know what CRRUA intended or did not intend to do?
would you rephrase that, please, Mr. Trio?
Do you have any reason to believe that CRRUA intentionally tried to exceed the arsenic standard in those tests?
No.
And you would agree that CRRUA had no obligation to inform the public of those test results. Is that correct?
No legal obligation.
No legal obligation. That implies that CRRUA didn't inform the public, but the CRRUA did inform the public. Is that correct?
I believe they did eventually, yes.
And was it you that requested or that approached CRRUA regarding participation in the comprehensive performance evaluation?
I was involved in that conversation.
I'm not sure. I'm trying to understand if that was actually like you were the point person and approaching CRRUA and asking, hey, would you be interested in participating in this?
I wouldn't consider myself the point person.
All right. Who was the point person then?
That would have been, I believe, our bureau chief, Joe Martino.
And CRRUA did participate in that third-party evaluation of CRRUA's arsenic treatment process, which included a thorough evaluation of all of CRRUA's operations. You've testified to that, right?
Yes.
And CRRUA was not obligated to do that, was it?
No.
CRRUA voluntarily agreed.
Yes.
Would you consider that a show of good faith to cooperate with NMED in undergoing a comprehensive performance evaluation that looked at every aspect of CRRUA's operations that it was not obligated to do?
I believe it was beneficial to their case to voluntarily cooperate.
So you don't believe, so you're not going to give CRRUA any credit for voluntarily agreeing to have a third-party evaluator come and itemize and scrutinize every aspect of its operations when it's not legally obligated to do so?
While I can give them credit for being cooperative once we intervened and stepped into this, I think the issue still comes back to whether they are actively engaged in making the changes to the management of the system that will get them to the point where they are providing consistent, safe water to their customers. And that yet remains to be seen.
So you would have preferred then that CRRUA, prior to any issues, proactively came to NMED and said, we would like you to conduct a comprehensive performance evaluation on us. That's what you would have preferred.
That would have been the preferred methodology, yes.
But CRRUA, in response to being approached, voluntarily agreed to do so. And that does say something about CRRUA's cooperativeness with this process, right?
Yes.
Are you familiar with the EPA's area-wide optimization program?
Somewhat.
Tell us what your basis of knowledge is.
Madam Officer, again, beyond the scope of my direct examination. Completely.
I'm sorry, Mr. Trujillo?
Yes, cross-examination does not just extend to only matters covered by the direct examination. It extends to matters that may modify, supplement, contradict, rebut, or make clear facts testified by a witness. I believe that.
No, I wanted the more specific statement as to how you're going to tie it.
General rule, then specific. So the fact of the matter is that Cabinet Secretary Roderick has testified extensively about CRRUA's lack of compliance, about CRRUA's failure to establish things on an ongoing, establish any trust with making long-term substantial changes. This goes directly to rebut that testimony.
Madam Officer, real quickly, but under section 20.1.5 400A 2, it's appropriate for the hearing officer to limit cross-examination that is unduly repetitious, harassing, or beyond the scope of the witness's direct testimony. And I believe Mr. Trujillo is going by the rules of civil evidence and not by the New Mexico Administrative Code that governs this proceeding.
Okay, so Mr. Trujillo, ask this question, and we'll see how far we can go here.
I'm sorry, I'm not sure if I understand the objection. The objection is that under the rule, this is repetitious.
No, I said, would you like me to read it?
Yes,
verbatim. Section 20.1.5.400A 2, examination of witnesses. I'm going to skip the first two sentences. The third sentence reads, the hearing officer may limit cross-examination that is unduly repetitious, harassing, or, and this is what I was referring to, beyond the scope of the witness's direct testimony. So this is beyond the scope of his direct testimony, and I'm asking her to limit the, based on that part of the rule, the third part.
Thank you for the clarification. I mean, the response would be, of course, this is the hearing officer's discretion.
Right.
And the fact of the matter is that this testimony, to which Mr. Roderick has testified that this is a new area of inquiry that directly rebuts something that he has previously testified to, which is that CRRUA is not proactively making long-term sustainable changes to its operations to justify
As he receive any credit. As he said, Madam Hearing Officer, it's a new area which is beyond the scope of the direct examination.
Okay, so the objection is overruled for now. We'll see how far we go with this line of questioning. Go ahead, Mr. Trujillo.
And it may not be long if you don't know. I mean, I'm here to ask you questions that you know about. So if you don't know what the AWOP program is, then you will save Mr. Riles lots of time.
Right. My knowledge of that, right knowledge is fairly limited, so I would refer you to some of our technical witnesses.
And are you aware that CRRUA has reached out to NMED directly, the local compliance office, I should specify, regarding board training, regarding its board members' roles and responsibilities? Were you aware of that?
I'm aware that they have reached out for some training, yes.
And were you aware that NMED provided that training?
I am.
And so that was a good step that you wish all utilities would do, correct?
That is correct.
And that was something that CRRUA was not obligated to do, that it voluntarily chose to do that, right?
That is correct.
And are you aware that CRRUA also requested and underwent a separate training and its board for CRRUA's staff and its board members from NMED Local Compliance Office regarding ERP and Emergency Response Plan?
Yes.
That was a good step that you wish all utilities would do, right?
Yes.
I know you testified that, I'm sorry. I know you testified that CRRUA hasn't applied for specific funds that you're aware of to help remedy some of the issues it faces, right?
Right.
But you don't know the whole story, right?
I don't know the specific facts, but in checking with our teams, I'm not aware that they have reached out.
So if I were to represent to you that CRRUA currently has 13 current grants that it's working on, you wouldn't have been aware of that when you testified, right?
Objection, Your Honor, it's speculation. He's asking to speculate.
No, he's asking him what he was aware of when he gave the testimony. Go ahead, Mr. Roderick.
In order to that, I would need to know what the grants, who the grants are with. They're not necessarily with NMED.
Right, that's the point. So what you testified is that CRRUA hasn't applied for any of these grants that I'm aware of, correct?
Correct.
So you don't know whether CRRUA has other grants from other funding sources, right?
Your Honor, he testified that CRRUA has not applied for any grants from his office, not every possible governmental entity or private entity that they might apply for a grant for. So this is, again, way beyond the scope.
I understand. I believe he's just confirming that Mr. Roderick is not aware of other granting sources.
I think it goes beyond that, Madam Hearing Officer.
Again, how
because
could he be?
Grant applications to other granting sources.
Again, how could he be?
He's just
precisely, I'm confirming.
shutting the door on that question. That's all.
But I think what it goes to, in response to Mr. Rail's objection, is that the testimony was CRRUA's, the implication that Mr. Roderick made is that CRRUA is not fixing its system because they're not applying for funds from us. But I'm confirming that he's not aware whether or not CRRUA has other funding sources that it's applied to. And so to the extent that that testimony is intended to disparage CRRUA for not seeking funding sources to fix its infrastructure, it's addressing the fact that he is limited to a very narrow view of that.
I understood what you were doing. Mr. Roderick?
Thank you. So I will acknowledge that they could be applying for sources other than through New Mexico Environment Department, and we might not have knowledge of it.
Thank you.
But I also think that this is an important point that needs to be made, that part of compliance is communication with your regulator. And if they are seeking funding, any designs that they come up with have to go through our office for approval before they can apply them. They have to have approvals. If they're seeking funding for a project that's going to have some type of a design before they can get the funding, it would make sense that they're making us aware of that so that we can make sure that what they're trying to get funding to build is actually allowed. And if that communication is not taking place, then it bodes problems down the line.
Thank you. Acknowledge. So would that require CRRUA to inform you personally of those designs?
It would not be a requirement to inform me, but they would need to inform the Drinking Water Bureau and their compliance officers.
And now when you say the Drinking Water Bureau and the compliance officers, let's be specific then. Are you talking about the local compliance officers in Las Cruces?
That would be probably their initial contact, but the actual plan designs have to be approved through our engineering section, which is not the local office. It would have to be pushed up to that engineering section to the bureau chief. Those decisions are not made at the local level.
So what I'm gathering is then that there's a chain of command. There's a chain of communication that takes place by CRRUA initiating it to the local compliance office, the local compliance office then referring it to an engineering section outside of the Las Cruces area. Is that correct?
No. CRRUA's responsibility is to refer it directly to the Drinking Water Bureau, to that engineering section. They have to submit those plans formally to us. It is not the responsibility of the local compliance officers to make that submittal happen. That is CRRUA's responsibility or their engineering firm.
Thank you.
Second.
Mr. Roderick, we're going to finish up pretty quick. I believe you testified that when I say this, I'm not trying to misconstrue your testimony. I'm trying to understand what the testimony was. I can't take perfect notes. But what I gathered that you testified was that NMED expects CRRUA to manage a system where exceedances don't occur. Is that what you said? Or if you could please clarify.
No, that is correct. That is the expectation.
So the expectation is that to manage a system where exceedances don't occur, but that's not the regulatory system that you enforce, is it?
Objection, Madam Hearing Officer. He's mischaracterizing Deputy Secretary Roderick's earlier testimony.
Would you rephrase that? I understand the point you're getting to, but just rephrase it, please.
The regulatory system that NMED enforces is based on the RAA, is it not?
Yes.
It's not based on single exceedances, correct?
Correct.
And so as long as CRRUA is in compliance with the RAA, CRRUA's water is safe to drink, correct?
While it may be safe for that particular constituent, to broadly state that it's safe is something that I can't do.
Right, because of the public health issues.
Right.
So in other words, the public health experts have determined that if this RAA is at a certain level, then that water is safe to drink, correct?
I believe that's correct.
And so if CRRUA is not above the RAA, CRRUA's water is safe to drink, correct?
Based on that standard, yes.
And so NMED is placing an expectation of CRRUA to have no exceedances when that's not the standard that you're legally allowed to enforce, correct?
Objection again, Madam Hearing Officer. He's again mischaracterizing what the Deputy Secretary testified to.
I don't think he's mischaracterizing Mr. Roderick's testimony. Mr. Roderick, you understand the question?
I do understand the question, and I think the issue becomes that it's the obligation of any public water system to provide safe water to their customers all the time. And to effectively play chicken, if you will, with that water by trying to operate a system and acknowledging or determining that a certain amount of exceedance is okay is not serving the customers appropriately. And I think that becomes the crux of the issue. As I stated earlier, that contaminant level for arsenic, that's the minimum standard. All right. That is the ground floor elevation, right? It doesn't say that it's perfectly safe. It says that's what EPA has set as an acceptable level as a minimum. The expectation is that a system will be operated in a manner that avoids those type of exceedances. And it's one thing if an exceedance occurs because you've had a system failure of some time, a catastrophic failure, something of that nature. And another where it occurs during the normal, what is asserted to be the normal operation of that system, right, on a daily basis, and then all of a sudden you get a spike. The only way that that spike can occur is if you have failed to adjust your treatment system to account for maybe a change in the groundwater. I don't know what led to it, but it's, again, the expectation is that a system is going to anticipate some of that and do what they need to do to avoid that, with the exception of when a catastrophic failure of some kind happens. That is not what's happened with CRRUA. It's not been due to a catastrophic failure. It's not been due to unforeseen circumstances. I believe, and this is my personal belief, that CRRUA should be able to anticipate and monitor closely what the water is doing, what their source water is doing, so that they can adjust so that no water that exceeds that gets out to their customers, barring a situation where they have an extreme failure of the system. That is not what we're talking about here. We're talking about a chronic situation that goes back to how it's being managed on a daily basis.
A chronic situation. What's your definition of chronic?
My definition of chronic would be something that is ongoing over a long period of time.
Okay. And so if over a year and a half, CRRUA engaged in 99 individual arsenic tests at its treatment facilities, and 6 of those results exceeded the arsenic standard over a year and a half out of 99 tests, is that chronic?
The fact that those exceedances occurred not associated with some type of a catastrophic failure of their system indicates a chronic failure of the management.
So in other words, if CRRUA, which has to affirmatively extract and treat its water to remove the arsenic, if CRRUA's exceedance is a 0.11 and the standard is a 0.10, and the next voluntary test is a 0.09, the 0.09 does not indicate a chronic problem, but the 0.11 does, correct?
Objection, Your Honor. He's putting words into the Secretary's mouth, and this is getting harassing at this point.
All right. So I don't know that it's getting harassing, but I think it is getting speculative. Are those test results in the record?
Yes, they are in the.
There's a
Westbury
0.9
Mission.
there's a 0.1.
I'm sorry.
There's a 0.9 and a 1.1.
There is that was a hypothetical.
Okay.
I was giving a hypothetical.
Thank you.
So those specific ones are not in the record. They very well may be, but that was a hypothetical. I'm trying to understand, Mr. Roderick, like what's the point of the RAA under this analysis if CRRUA is to be held to a separate standard than the legal standard that it's actually required to comply with?
Your Honor, he's asking, again, this is speculative and
So I don't believe it is speculative. However, I think Mr. Roderick has addressed this question now twice that I remember. Do you have anything to add to your previous answers to this question, which seems to be why is CRRUA being held effectively to a higher standard than the law as to the rolling average with these individual spikes? Do you have anything to add?
I don't have anything to add.
Okay. I think he's provided the best answer.
Two to three more questions, barring. So if you don't know why, I'm sorry. NMED has alleged that CRRUA has engaged in bad faith conduct through the voluntary arsenic test on April 23rd, May 6th, and the compliance test of May 7th, 2025. Would you agree that bad faith requires some kind of intentionality component to it?
Madam Hearing Officer, again, that's not what Deputy Secretary Roderick.
I'm going to stop you because he did use those words.
He used them. What he said, Madam Hearing Officer, is that CRRUA engaged in bad faith, and that the April, the May, and the 2 May tests were things that could be considered to add the bad faith enhancement. He was talking about CRRUA's behavior over the last 15 years, not about those 3 specific instances. And so he's mischaracterizing what Deputy Secretary Roderick said.
Okay, Mr. Roderick actually spoke the words intentional act when he was talking about the
bypass,
the egregious. Yeah, okay.
Yeah, but that's not what Mr. Trujillo is referring to. Mr. Trujillo is referring to 3 tests that happened after the ACO was the stipulated penalty was agreed to, and he's trying to insinuate that we are basing the bad faith enhancement on those three things alone, and not on what Deputy Secretary Roderick testified was the entirety of their behavior over the last 15 years.
Okay,
it's not an insinuation, Madam Hearing Officer. The amended administrative compliance order expressly and specifically states that the May 6th, the April 23rd, and the May 7th test results were bad evidence of bad faith conduct on CRRUA's part. It's express.
Right.
The 3-day and the 9-day delay were further evidence of bad faith. The amended administrative compliance order makes 0 mention or 0 reference to any history of non-compliance. And so to the extent that I can ask Deputy Cabinet Secretary Roderick about how voluntary tests in a compliance sample that do not qualify or constitute violations under the arsenic standards that they are required to enforce, how that can be construed to be bad faith conduct when there's been 0 reference anywhere about a history of non-compliance until this opening statement.
All right, thank you. The objection's overruled. Mr. Roderick, can you address the question?
Yes.
Would you like me to rephrase? Would you like me to ask it again? And I'm going to step back and say that NMED has adopted the RAA standard, correct?
Yes.
That's NMED's standard. And so when we're talking about the April 23rd, 2025 test and the May 6th voluntary test and the May 7th compliance sample that did not constitute violations of the arsenic standard, if they don't constitute violations of the arsenic standard, and if they are part of NMED's interpretation that CRRUA should be held to a higher standard, is that why they're bad faith? Because CRRUA is being held to a higher standard?
They're considered bad faith because what they indicate is the decision, apparently on CRRUA's part, to operate their system in a manner that operates as close to that maximum level as possible without going over it. Good faith would be to operate your system in a manner that keeps you well below that to protect your customers. And the fact that they're operating up and hitting that level and having exceedances, it's strictly due to operation of the system. You know, you reduce the levels of arsenic by increasing the treatment. And if they are not increasing the treatment to keep it down so that they have a safe area to operate within, I don't know how that can be construed as anything other than bad faith when this whole process has been to help them improve and with their cooperation to improve their relationship with the community, to enhance the operation of the system, to become fully compliant.
You agreed that CRRUA didn't intentionally try to result in exceedances, right?
Asked and answered, Mr.
I'm asking you.
You already did.
I'm sorry. you agree, you testified previously that CRRUA did not intentionally try to exceed the arsenic, the MCL. So are you saying that?
Madam Hearing Officer, I don't remember Deputy Secretary Roderick testifying that CRRUA didn't intentionally try to exceed the arsenic level?
That's my memory.
Okay.
Finish
I'm sorry.
All right. Finish your sentence.
I'm sorry, what was there was a clarification.
I didn't recall that Deputy Secretary Roderick said that they didn't intentionally, in my question of him, that I didn't recall that, but apparently the hearing officer does, in her opinion, is the one that had a slight retract.
I'm sorry, Madam Hearing Officer.
I do remember that he agreed that he had no reason to believe or no evidence
that there was intentional. Yes.
that there was an intentional exceedance of the MCL. Okay.
Thank you. Okay. So there's no intentional exceedance of the MCL. And so it sounds to me like you have a running annual average standard, correct?
Correct.
And then you have any exceedance that does not violate the running annual average standard or CRRUA equals bad faith. Is that your testimony?
Not any exceedance. I believe it's the issue of being in the middle of this process of bringing them into compliance, of operating inside this order, and the fact that for whatever reason that I don't understand, they are not operating their system in a manner that creates a buffer to prevent them exceeding that. They are skirting that at times, and whether that is due to the fact that they are not monitoring their system appropriately or all the time, I do not understand, don't have knowledge of why that would be the case. I do have knowledge that one of the recommendations that has not occurred is to to make the system automated so that it is tracking in real time the levels in the water, so that it allows them and the system to move to that, to adjust to that. I'm not aware that that is in place yet. If it was, and if it was adjusted appropriately, they could create that buffer, if you will, that would help them prevent an exceedance. The intent is that they react to it before it exceeds so that the public is never at risk.
And is a buffer a regulatory standard?
No.
Mr. Trujillo, are you nearly finished?
Yes, I'm close. So if the April 23rd, May 6th, and May 7th arsenic test were such conduct of bad faith, why didn't NMED just issue a new compliance order?
You know, that's a decision that I wasn't specifically involved with, and that I would have to refer that to our legal counsel. I can't answer why we opted to go the way we did.
Is it because they weren't violations of the arsenic standard?
Asked and answered.
He said he cannot answer. You have to respect that.
You testified about two outstanding deficiencies in the 2023 sanitary survey, and they were, I believe, SCADA and erosion at one of the holding tanks. Is that correct?
I don't recall testifying to it.
Okay. I believe you testified that a best practice for CRRUA would be to implement a SCADA program, right?
I did, and that was a recommendation that came out of the comprehensive performance evaluation.
And are you familiar with the cost of the SCADA program?
It's expensive. They varied based on the requirements of the specific system. So I don't have a specific cost.
But you said it's expensive.
They're not true.
Now, are you familiar with one of the outstanding deficiencies at CRRUA is the erosion at one of its holding tanks? If you're not, that's fine.
Not specifically.
If I represented to you that that was one of the outstanding deficiencies, would you have any reason to disbelieve that?
No.
And if I represented to you that the cost of addressing the erosion at one of the holding tanks was over 600,000. Would you have any reason to believe that?
Would I have any reason to believe that?
Any reason to disbelieve that? Thank you for the clarification.
No, I wouldn't.
And so you're familiar with the ERG report because you requested it, and you stated that the ERG report was impartial, correct?
Yes.
And the ERG report stated that CRRUA is chronically underfunded, that its budget is suffering, and that it does not have sufficient funds to pay for regular operations and maintenance of its system. And so would you believe that based upon the outstanding deficiencies that CRRUA has, as well as the evidence in the ERG report, that CRRUA has a legitimate ability to pay request in regards to the civil penalty in this matter?
I don't believe I'm qualified to speak on whether CRRUA is able to pay that or not.
Thank you.
We need a 15-minute break. Let's come back at 2:55. We're almost there, Mr. Rowder. Mr. Real, do you have redirect?
Yes, Madam Hearing Officer, but Mr. Trujillo's not back in the room. Would you like me to proceed with that? I'd be glad to.
Yes.
That was a joke, of course.
Let me just mention we will have to vacate the room by 5. Five. Sorry.
I told him to wait for you, Don. I said, let's wait for him.
Mr. Ray. Okay. Mr. Ray.
Thank you, Madam Hearing Officer. I'll try to be as quick as I can. Mr. Secretary, you said that the CFR that Mr. Trujillo referred to as a floor and not a ceiling. Is that correct?
That's correct.
So, in other words, the requirements of the CFR are the minimum that NMED can do, but not the maximum. Isn't that right?
That would be correct.
I ask counsel not to lead his witness.
Yeah, he has a point.
Okay. See where I want to go here. I made so many notes. Mr. Secretary, does the ACO require 100% correction of significant deficiencies?
That's correct.
But what does failure to, well, let me say it this way. The ACO does not require 100% correction of significant deficiencies like Mr. Trujillo said. Is that correct?
Would you restate that?
So, Mr. Trujillo asked you a question earlier about whether or not the fact that they don't have a SCADA system, except the soil erosion, that is not required. Those two are not required. It would be a best practice, correct?
Correct.
But what does the fact that CRRUA has not corrected all of their significant deficiencies, what does that tell you?
It speaks to the fact that for whatever reason, CRRUA is not moving forward with correcting those things in a timely fashion is more than likely not dedicating the resources appropriately by determining what are the most critical elements that are going to provide the highest level of protection to the public.
So, Mr. Secretary, in addition to your familiarity with the CFR incorporated in the drinking water regulations, are you familiar with the remainder of those drinking water regulations?
Yes, sir.
And would you please tell us, Deputy Secretary, what those drinking water regulations say about how NMED may use monitoring samples?
Yes, specifically in 20.7.10.503 under Department of Monitoring and Sampling, we're not prohibited from using any sampling with regard to compliance, nor are we prohibited from taking samples as we determine to be necessary with regard to determining compliance.
So under that section of the drinking water regulations, NMED very well could have chosen to use those 10 samples or the 3 samples that Mr. Trujillo just talked about. You very well could have chosen to use those samples as part of this enforcement action or as part of an ACO. Is that correct?
That is correct. We are prohibited from being less restrictive than the federal regulation, but we are not prohibited from being more restrictive.
Thank you, Mr. Secretary. Speaking of the three new samples that Mr. Trujillo was talking about, the April 23rd, 2025 sample of 12 parts per billion, the May 6th sample of 12 parts per billion, and the May 7th sample conducted by NMED of 15 parts per billion. That's all new information. Are you allowed to consider that new information when you're looking at bad faith enhancement under the penalty policy?
Yes.
And what does it say about CRRUA that in the middle of an ACO, they're about to have a hearing, we're in the middle of negotiating? What does it say? And what does it say that they had 3 positive tests in a 2-week period above the arsenic level? Mr. Trujillo seems to say that that doesn't mean anything, that it doesn't amount to a violation. What does that amount to in your mind, Mr. Secretary?
Well, I think that I first want to clarify something to do with the bad faith argument. And that is, I think it's important to note that we're not actually talking about bad faith towards the department. We're talking about bad faith towards their customers and the department intervening on behalf of those customers, because that's our job, to protect the public health. And the fact that these exceedances occurred, and again, not associated with some type of a catastrophic, unpreventable system failure, but occurred in the course of their normal day-to-day operations, would indicate to me that they are operating as close as they can to that limit. For what reason, I don't know. But if they were really acting in good faith, they would be doing everything that they can to reduce that arsenic level, just not to the allowable minimum, but as low as possible to ensure the protection of their customers.
So, in other words, even though CRRUA did not have a legal obligation, as described by Mr. Trujillo, did it have a different type of obligation to provide public notice in your mind of those exceedances, those 3 exceedances in a row?
I believe that what we're again talking about now is bad faith towards their customers. I think that there is, while maybe not a legal obligation, an absolute moral obligation to do what they need to do to protect their customers all the time.
Thank you, Mr. Secretary. A lot was made about the sampling that was conducted on March 15th of 2024. Was that sampling conducted for enforcement purposes?
No, that sampling, the intent of that sampling was to corroborate information that we were getting from CRRUA. And it was actually done with the intent of being able to show the public that they could have some faith in the information that CRRUA was providing to them. You know, my hope would have been that all the samples came back clean and we could say, look, we just verified that CRRUA is doing a good job, that there's a clean bill of health here. Didn't quite work out that way, but we provided the information based on the facts, which was that sampling.
And those March 15th, 2024 samples, they weren't used for the penalty assessments in this case. Is that correct?
That's correct.
You just said that it was done, you were hoping that it would serve to reassure the public if all 10 of those samples had come back clean. Let's go to that March 28th press release that Mr. Trujillo showed you and questioned you about. Would you have issued that press release if the 10 samples had come back clean?
Absolutely.
And why would you have done that?
Because that is part of notifying the public, making them aware, and building trust.
And you feel like that trust was eroded not just in CRRUA, but is also spilled over to be eroding the public's trust in NMED? Objection. Lee. Do you feel, let me restate it, Madam Hearing Officer, do you feel, you testified earlier, I should say, that that not only has the public's trust in CRRUA been eroded, but do you also feel that the public's trust in NMED has been eroded?
I don't feel that. I know that for a fact based on conversations with customers down in that area, in Sunland Park area.
Speaking of those samples, would you want to know, even though it's, you know, not for enforcement purposes, would you want to know if you were for a consumer, would you want to know that they had 3 samples in a row that exceeded the arsenic MCL?
I certainly would. You know, and I'm not a consumer at CRRUA, but I'm a consumer of a large water system here in New Mexico, and I expect to have safe water all the time, and I expect to know any time that it is at risk, even potentially. So I don't think that's an unreasonable expectation at all, and it's doing the right thing by your customers.
Speaking of doing the right thing, Mr. Trujillo did a good job, in my opinion, of establishing that CRRUA has been taking some actions that he went over in detail, such as requesting training from NMED, such as I think you said they requested a couple of different types of training, and he asked whether or not that meant that was a positive thing in your mind. Is that something that you earlier testified that you felt like CRRUA's approach to water management was reactionary? Is that something you feel was reactionary?
I do. It was all done. All these actions, the SOPs, the request for training, everything that's happened only occurred after the fact, and the fact being that they got caught.
So Mr. Trujillo made a point of pointing out to you that they now have SOPs in place after the CPE. Should they have had those SOPs in place prior to the CPE?
Absolutely.
Should they have had those SOPs in place 15 years ago?
Absolutely.
Mr. Trujillo asked you, well, wait, he also made a point to point out that CRRUA had voluntarily participated in the CPE that was done by ERG, what he was referring to as the ERG report. You think that their participation in the CPE is laudable?
I think that their participation is good, but again, it occurred after the fact and only after we found the violations and we initiated this entire thing. And at our strong recommendation, they agreed to it.
And after you did, who agreed to pay for the CPE?
NMED paid for the cost of that.
So was this also something that you view as reactionary on the part of CRRUA, their participation voluntarily in the CPE?
Absolutely. I do not believe that they would have commissioned any firm to come in and do that CPE had they not been under the gun with NMED.
So the SOPs that were developed in response to NMED's action, the participation in the CPE voluntarily, etc., do those things negate the factors considered by NMED when they were looking at this bad faith enhancement?
No, they don't.
a couple more things. Mr. Trujillo made a point to talk about the fact that CRRUA did not intentionally exceed the arsenic levels, right? Right?
Correct.
But what about intentionally bypassing their arsenic treatment system on numerous occasions, one time for over a year? Is that intentional behavior in your mind?
That can be nothing but intentional behavior.
Does that amount to bad faith in your mind?
Absolutely amounts to bad faith.
And the failure to notify its consumers and or NMED, does that amount to bad faith?
Absolutely.
One other thing, Mr. Trio made a big point about the fact that they are in compliance. How do you know if a system is in compliance if your sanitary surveys are every 3 years? Isn't it possible theoretically that a system could be in compliance and some time can pass during that 3 years and you would not know something was happening within that system unless that system reported it to you as they're required to do by the law?
Objection.
Objection.
Leading, I mean, I think he's leading the witness right down the path by giving him a handful of nuggets of information and asking him, correct?
Okay, just rephrase, please.
Fair enough. How often are sanitary surveys conducted, Mr. Secretary?
Sanitary surveys are conducted on a 3-year rotation.
So if I run a water system and I have just completed my sanitary survey and I've passed it, is it conceivable that I could I could have a number of violations of a number of different issues, and if I fail to report them to NMED, that I would not be caught?
I believe that assumption would be correct, that it speaks to the fact that we expect systems to operate in good faith and to notify us and to notify their customers when there is a problem, rather than us having to try and catch them doing something wrong. That's not an effective use of our resources or effective operation of a system.
And has that been your experience with CRRUA?
That has been the experience with CRRUA.
What has been?
The fact that in this particular instance, they knew they had a situation, they made a decision to shut down the arsenic treatment system, which put their customers at risk, and made the decision not to report that to the customers and certainly not to report that to us. And we caught them. Then all of a sudden, they're willing to play ball and willing to try and correct things. My sense is that had we not caught them when we did in December, we probably would have caught them later December when we did the sanitary survey. But if it hadn't been scheduled right then, who knows how long they would continue not to operate that arsenic and not to report it.
So they made an intentional decision to bypass their arsenic treatment system. They failed to report it to you. They failed to report it to the public for over a year. That's all stipulated to. So to use Mr. Trujillo's words, Mr. Secretary, once those violations have occurred, can you unring that bell?
No. The violations occurred. The public was potentially impacted by that. Obviously, the public trust was impacted by that. You can't change that. The intent of the ACO and the intent of everything that we're doing right now is to change their behavior to ensure that they're doing right by the public, that they're not riding as close to the edge as they can possibly get with compliance, that they are actively engaged in being the best system that they can be. They've not demonstrated that.
Thank you, Mr. Secretary. I have no further questions for you. I'd like to thank you for spending your day here today with us in this hot room.
Thank you, Mr. Real. Any reason not to excuse Mr. Roderick? Thank you very much, Mr. Roderick.
Thank you.
Your next witness.
Thank you, Madam Hearing Officer. NMED calls Brandy Littleton to the stand.
If you would please state and spell your first and last name. Is the microphone in front of you on?
Now,
Yes, now.
do that again?
No, it's all right.
Okay.
Do you swear or affirm to tell the truth?
Yes, I do.
Thank you very much. Go ahead, Mr. Rea.
Ms. Littleton, I felt foolish earlier when the Deputy Secretary Roderick had already stated his name, so I'm not going to ask your name again. Where are you currently employed?
In Las Cruces
With whom?
with the New Mexico Environment Department
And how long have you been with the New Mexico Environment Department?
since 2011.
And what is your current job title?
Compliance supervisor
And for what region?
for the Southern Compliance Supervisor
How long have you been in that position, Ms. Littleton?
since 2016.
What area do you cover as Southern Compliance Supervisor?
Generally, it's from I-40 south,
The whole state?
the whole state,
Okay.
about 400 systems.
Okay. And Ms. Littleton, can you tell us a little bit about the career path that led you to being Compliance Supervisor for the state of New Mexico?
I started out of college with the City of Hobbs as a lab technician, then as the lab manager. From then, in 2011, I moved over to the state of New Mexico with the Environment Department as a compliance officer. I was out of the Hobbs field office. In 2016, I became the supervisor, the Southern Compliance Supervisor, and then I moved to Las Cruces.
And is that where you're currently stationed?
Yes, it is.
Ms. Littleton, I'm going to skip ahead a little bit because we've covered a lot of this, but when do systems get issued a violation for exceeding an MCL?
Whenever they exceed an MCL, it is because they're running annual average, which means the quarterly samples make up the running annual average, and that is over the MCL.
And what's the MCL for arsenic?
10 parts per billion.
So if a system is over MCL for arsenic, say for example, what happens?
If they're over the MCL, we'll run some reports to ensure that their running annual average is over the MCL. We generate the violation letter, and then we'll issue it to the water system.
Okay. And what happens next?
The water system is required to provide public notice to their customers within the violation that were originally issued to them. And then they're required to do something with their system to ensure that they're providing safe drinking water to their customers.
So to Mr. Trujillo's point earlier, if a system has 3 samples that are at or below the MCL, and then one system that is above, but not high enough that the running annual average is above the MCL for the year, is that a violation?
No, it is not.
Okay. What if a system has 3 samples that are at or below the MCL, and then one sample that is so far above it that the entire running annual average is now above the MCL? Is that a violation?
Yes, it is.
Who sets the MCL levels?
It is set by federal EPA and state drinking water regulations.
So, in other words, has New Mexico adopted the EPA regulations for itself?
Yes.
Could the state of New Mexico adopt its own MCL if it so chose?
I don't think so. I guess if we wanted to, we could exceed if we actually have more stringent regulations in the EPA if we chose to, but we actually go with what the EPA is for the MCL of arsenic.
Okay. So let me see if I have this correct. Systems do not receive a notice of violation if the running annual average does not go above the MCL, but they do receive a notice that they had an individual sample above the MCL. Is that correct?
If the running annual average is above the MCL.
If the running annual average is not above the MCL, but they have one sample that is above the MCL, do they receive a notice?
No, they don't, but they do receive the lab report that shows that they were over the MCL.
So that lab report, would that serve basically as an early warning system that they need to do something different to bring their system back into compliance with the MCL level?
I would think so.
Back into compliance with the that they should do something to ensure that their next sample is not also above the MCL level?
Yes.
Is that a fair way to
Yes.
put it? Okay. What happens if a system can't stay under the MCL and they stay out of compliance?
If they stay out of compliance with enough samples, they are issued an administrative compliance order.
Okay, and let me ask you this. So what is the process for, so would they first be issued a violation?
They would be issued a violation
Okay.
for exceeding the running annual average MCL.
Okay, and what's the process for issuing violations that your office takes?
It starts with the certified samplers who collect the samples from the entry points. They get the samples to the labs. The labs analyze them and provide us with preliminary reports if they are exceeding the MCL, so we can be looking out for them. If they are over the MCL, they upload those results into the database. The lab takes care of that. Once the results are in the database, we can run our own reports, CDS reports, and those reports can be used to show that the running annual average at certain locations is over the MCL. And we use that as kind of a notification that the samples are now they're now public samples within our database, and then we issue the violations to them.
And this is all after you've taken those samples, correct?
Yes.
Okay. When you say we send out violations, who specifically sends the violations out?
It just depends. In the past, the compliance officers would send those out. Our violations are time sensitive because of the public notice. They have to provide public notice within a certain amount of time from the date on the NOVs. So if, just to say, someone from my staff was on vacation or something, then I would issue those for them.
Okay. As substance compliance supervisor, you've had interactions in the past with CRRUA, is that correct?
I have. I first became aware of them in 2016 when I first moved to Las Cruces.
Okay. Can you tell me what brought CRRUA to your attention in 2016?
I had moved to Las Cruces. I didn't know anything about any of the water systems. I just started running some reports to see the water quality and to see what needed to be done in the area. And I found that a number of violations had not been issued to them. So I started issuing those violations, and it just so happened that I believe it was 31 violations that I issued to them.
By them, do you mean CRRUA?
CRRUA.
Yeah. So when you were running reports, when you got into your position, you were running reports on multiple water systems?
Water systems in the South.
Okay. And then you ended up finding that CRRUA was out of compliance?
Yes.
Okay. And so at that point, you issued violations?
I issued them the violations, and that's, issuing 31 violations at once. That's a big deal. It becomes, now they're on our radar, and we're trying to figure out what's going on with them, that they have been out of compliance for so many years.
Did they give you any indication as to why they received 31 violations?
They didn't until I conducted the sanitary survey.
Are you referring to the 2016 sanitary survey?
Yes.
Can you tell us what you found out at that 2016 sanitary survey?
I found out that they were bypassing the treatment at the Sunland and the industrial treatment plants, arsenic treatment plants.
Okay. And how did you find that out?
I showed up and there was a team, multiple teams of engineers at the treatment plants that were working on repairs. Just speaking with the engineers, speaking with Brett Westmoreland, the director at the time. He notified me that the treatment plants were being bypassed. They had some repairs to make to them. According to them, the operator was not trained and didn't really know how to make the repairs to the system, so they bypassed them.
Did Mr. Westmoreland give any explanation as to why they chose not to make those repairs?
No, he did not.
Okay. Did CRRUA report to you? Did anyone from CRRUA other than the engineers that were there report to you prior to the sanitary survey that they had taken the treatment plant offline?
No, they did not. Not to me. And I mean, I didn't get there until 2016. So I don't know if they provided that information to somebody else or not.
Did they indicate how long that the system had been offline in 2016?
No, they didn't at that time. But if you look at the MCL violations that I had issued to them, it had been over a year.
Okay. Did CRRUA receive any notice that they had bypassed the system?
No, they didn't get like a formal violation letter. It was noted in the sanitary survey report.
Okay, so even if CRRUA did not receive a formal violation or notice of violation in 2016, should CRRUA's management have known that they weren't supposed to be bypassing those treatment plants?
Yes.
You said that you issued a series of violations, 31 in all. Were those all resolved without any additional enforcement actions?
No, they were not.
To your knowledge, was an ACO issued following those violations?
Yes.
And who issued that ACO?
The enforcement officer, Maria Medina.
Okay. Ms. Littleton, I'm going to direct your attention to that book there in front of you to what has been marked as NMED's Exhibit 6. Let me know when you have that open in front of you.
Okay. Yes, I do.
Have you reviewed NMED's Exhibit 6 prior to testifying here today?
Yes, I have.
Are you familiar with the document marked before you marked as NMED's Exhibit 6?
Yes.
Are you familiar with the contents of NMED's Exhibit 6?
Yes, I am.
What is NMED's Exhibit 6?
It is an administrative compliance order to Camino Real, and in it, it is for exceeding the arsenic MCL and not providing public notice to customers.
And is that the 2016 ACO?
Yes, it is.
Is this a true and correct copy of the 2016 administrative compliance order?
Yes, it is.
Madam Hearing Officer, at this time, I would like to move to enter NMED's Exhibit 6 into evidence.
Objection?
Same prior objections.
Right, overruled. 6 is admitted.
Thank you. Ms. Littleton, can you please explain to me very briefly what the violations in this order are?
They were for exceeding the MCL running annual average at different entry point locations.
Anything else they failed to do?
They failed to provide public notice to customers.
When they found out about those violations from the, I'm sorry. So you're saying that even though they knew about the violations, they failed to provide, after the sanitary survey, they failed to provide the public notice that was required to their consumers at that time?
Yes, every MCL violation that they receive has a public notice requirement to it.
Okay. And did the ACO contain violations for exceeding the MCL for how many systems that CRRUA manages how many systems that CRRUA manages violated the MCL level in this 2016 ACO?
I believe it was all of them, all 4 of them.
Okay. After the 2016 ACO was issued, when was the next sanitary survey conducted?
It was conducted in 2019 by Antonio Romero.
And Ms. Littleton, I'd like for you to look, to refer you to the exhibit marked as NMED's Exhibit 9 in that book. And let me know when you have it in front of you.
Okay, that.
Have you reviewed NMED's Exhibit 9 prior to testifying here today?
Yes, I have.
Are you familiar with the document marked as NMED's Exhibit 9?
Yes, I am.
Are you familiar with the contents of NMED's Exhibit 9?
Yes.
What is NMED's Exhibit 9, Ms. Littleton?
It is the 2019 sanitary survey conducted at Camino Real.
And is there a cover letter or address on top?
Yes, it is.
Is it addressed to anyone?
To Brett Westmoreland.
And who is Brett Westmoreland?
At the time, he was the director for CRRUA.
Okay.
And we have him listed as administrative contact, so that's who we would send all correspondence to.
Is NMED's Exhibit 9 a true and correct copy of the 2019 sanitary survey?
Yes, it is.
Madam Hearing Officer, at this time, I'd like to move to enter NMED's Exhibit 9 into evidence.
Objection?
No objection.
9 is admitted.
Ms. Littleton, what obligations do systems have in relation to, wait, I'm sorry, page. Yes. According to NMED's Exhibit 9, on what date did CRRUA receive notification regarding the results of the 2019 sanitary survey?
On October 15th of 2019.
And according to the sanitary survey report, what was discovered? How many significant deficiencies were discovered?
I believe 9 significant deficiencies.
Okay. And what does a significant deficiency mean?
It's anything that we find during the course of the sanitary survey that has the potential to cause the threat to public health.
Okay. Public health, safety, welfare.
Yes.
So significant deficiencies, in other words, could be harmful for consumers.
Yes.
What obligations did CRRUA have in relation to those significant deficiencies?
They had 30 days to provide us with a corrective action plan, 30 days for the date on the sanitary survey report. Then they have 120 days from the date on the sanitary survey report to provide us with corrections for all significant deficiencies.
And what happens if they don't submit a corrective action plan within 30 days?
Then they're issued a notice of violation with a public notice requirement.
Okay. Where did the 30-day timeline and the 120-day timeline, where did those come from?
From drinking water regulations.
The state of New Mexico?
New Mexico.
What happens if the drinking water system does not correct the significant deficiencies within the 120-day deadline?
They're issued a violation with a public notice requirement.
Did CRRUA submit a corrective action plan after receiving this 2019 letter and report with within the 30-day requirement?
No, they did not.
Did they submit one at all?
Yes, they did. It was late.
Do you know on what date they submitted it?
I believe it was December the 15th.
If I represented you that it was December 5th, 2019,
yeah,
that sound correct?
Yeah, that sounds good.
That's significantly longer than the 30 days that are allowed, is that?
Yes.
Did they provide any explanation as to why it took so long to provide the corrective action plan?
No, they didn't. They didn't to me. Otherwise, they may have to their compliance officer, who was Antonio Romero at the time, but they didn't provide me with anything.
Okay. Did you see anything in the report to that would signal that CRRUA had provided Mr. Romero with anything? Would he have reported that to you?
No. No, I didn't see anything.
Would he have reported to you if they did ask for an extension, for example?
Yes.
Would you
yes.
have had to approve that?
Yes, I would have.
Okay. Did CRRUA correct the significant deficiencies contained in the 2019 survey without any further enforcement actions?
No, they did not. They did not correct the storage tank. the storage tank inspections.
So to be clear, CRRUA did not come into compliance in a timely manner after the 2019 sanitary survey. Is that correct?
That's correct.
Did you issue any notices of violation for CRRUA's failure to correct the significant deficiencies on time?
Yes, we did.
When did you do that?
We issued them a violation for the corrective action plan being late, and then an additional violation after the 120-day deadline. We would have issued the violation for not correcting all significant deficiencies.
And this was still back in 2019, 2020
Yes.
timeframe, early 2020?
Yes.
Did any significant deficiencies from the 2019 sanitary survey exist when the administrative compliance order was issued in 2024, the one that we're here talking about today?
Yes, they still hadn't corrected the deficiencies for the storage tank inspections.
So over 5 years later, they still had not corrected the significant deficiencies in the 2019 sanitary survey?
Yes.
Any explanation from them as to why they failed to do that?
No.
Following the 2019 sanitary survey, when did NMED next conduct a sanitary survey of the CRRUA system?
December the 5th and 6th of 2023.
And were you present for the 2023 sanitary survey?
Yes, I was.
What did you learn while you were at CRRUA for the 2023 sanitary survey?
I learned that they were again bypassing their treatment at the Sunland Park and the industrial park.
Okay. Who told you that?
Typically, I will address the certified operator when I'm conducting the sanitary survey. So I spoke with their certified operator, Ernie Carranza, and he mentioned that the treatment plants were currently offline, and he said it was due to a replacement of some skids, and they were having to do some maintenance on them. After he had provided me with his explanation, then I asked him, I just kind of let him know that I had spoken to Brett Westmoreland in September of that year and asked him about the treatment plants. And he gave me the exact same explanation and said that they weren't running at that time. When I asked him, like, was he sure that it had just been a couple of weeks or had it been longer than that? At that time, JC Crosby had told me, and I felt that he was kind of embarrassed, and he said that, you know, he was kind of embarrassed to admit that they had been offline for some time. They had been bypassing them. So, I mean, we still weren't clear on exactly what the time frame was, but at this point we knew it was a couple of months. Later in the inspection at the industrial arsenic treatment plant, I spoke with their hired engineer, Eric Lopez, and he mentioned that they had been off for, he thought, more like a year.
And if I represent to you that the sanitary survey report says that they had intentionally bypassed the arsenic treatment system at 3 of their plants, would that sound correct to you?
Yes.
Okay. So all but the border plant then, basically?
Yes, and it was the border plant was actually not up and running at that point, or, you know, it actually was just barely up and running. It had just barely been constructed, and it was barely in use.
So at the 2023 sanitary survey, who was present from CRRUA? You mentioned Ernest Carranza.
Carranza, JC, and Eric Lopez.
Okay. And JC Crosby is Juan Carlos Crosby?
Yes, it is.
And what is Mr. Crosby's job? What was Mr. Crosby's job title at that time?
He was the assistant deputy director, I believe, or just maybe not deputy.
Assistant
director or something. CRRUA.
was Assistant Executive Director, sound
Yeah.
correct? Okay. What is Mr. Crosby's job title now?
He is the director now.
Okay. And you mentioned Ernie Carranza. What is his job title?
He is the certified operator for CRRUA.
The lead operator?
He's a lead operator, I believe he's a level 4.
So for over a year, after speaking with those gentlemen as well as Mr. Lopez, you're telling me that for over a year they were serving constituents with water that wasn't treated for arsenic? Objection. Leading.
Oh, yeah, just be careful about the leading.
Okay, should I rephrase, Madam Mayor?
Yes, please.
Would it be safe to say, after discussing with those, with Mr. Crosby, Mr. Carranza, and Mr. Lopez, you just testified that they admitted that the arsenic treatment plants had been offline for over a year. Is that correct?
That's correct.
Okay. And would that mean that they were serving water that had not been treated for arsenic to their consumers for that period of time?
That is correct.
Okay. What can you tell me about the side effects of arsenic?
Objection. Yeah, foundation. I mean, I just don't think this witness has demonstrated any.
If you would, Mr. Rael, establish some foundation, please.
Yeah, I guess what I'm doing is, Madam Hearing Officer, I'm asking Ms. Littleton what she can tell me about the side effects of arsenic, her personal knowledge, if she has any.
I'm just going to object. I mean, I don't think the lay opinion rises to a level of, formal evidence in regards to.
Yeah.
Did you say side effects?
All right, let me skip it. Let me ask it this way, if I may. Ms. Littleton, knowing what you do in your experience as Southern Compliance Supervisor, I assume you have an education, correct?
Yes, I do.
And quite a bit of experience with arsenic.
Yes.
Would you let your children drink water that was?
I'm going to object again. I mean, that's not a proper foundation for anything resembling technical testimony.
And Ms. Rail, it's not actually a proper question at all. She's here in her professional capacity, and her personal opinion about that as a parent, for example, really isn't relevant.
Okay, thank you, Madam Mayor. I'll move on. You testified that you, let me ask this. How did, when you came into your position as Southern Compliance Supervisor and you moved to Las Cruces, you testified that you became familiar with CRRUA system. You found all of these violations. They didn't correct everything from the 2016 violation. They didn't correct everything from the 2019 sanitary survey. How did that make you feel about their operations, about their compliance? Did you feel good about them?
That's kind of a loaded question, and I have a lot. I don't trust them. I've worked since I've moved to Cruces with Brett Westmoreland, visited with him, talked with him. I just never felt that he was being honest. I completely felt that it was more about making money than it was about providing safe drinking water to customers. Just from the conversations I had with him, and his excuses, as far as bypassing the treatment plants and saying that they had just barely taken them offline. I didn't feel comfortable with him at that time, which is why I put him on a quarterly schedule, because I literally felt like he was lying to me, and he was. And so then that's how, I determined that, with quarterly samplings, and all of a sudden the samples are coming, the results are over the MCL for arsenic. So my interactions with CRRUA and Brett Westmoreland weren't positive.
Is it fair to say that CRRUA based on your experience with them, has a history of intentionally bypassing the arsenic treatment plants and not informing the department?
Objection. Leading again.
I asked based on her experience.
Yeah.
Based on your experience, do you agree that that's the leading question?
I didn't call for an answer. I asked her.
Is it right? That's overruled. Do you remember the question?
I don't remember.
Sorry.
Do you have an opinion as to finish the
Ms.
sentence?
Littleton, is it fair to say that based on your experience with CRRUA, that they have a history of intentionally, do they have a history of intentionally bypassing the arsenic treatment plants?
Yes, they do.
And when they've bypassed their arsenic treatment plants, have they informed the department, the environment department?
No.
Do they have a history of not, do they inform the public as they're required to when they intentionally bypass their arsenic treatment plants?
No, they did not.
Did CRRUA report that they had taken their treatment plants offline in 2023 to you or the environment department?
No, it was, we found out we were conducting the sanitary survey.
Right. And they are they required to inform the department if the system is taken offline for an extended amount of time, and not just for, say, maintenance?
Yes, they are.
And are they required to inform the public as well?
Yes, they are.
I'd like to direct your attention now to NMED's Exhibit 13 in that book. Let me know when you have it ready. No objection.
All right, thank you very much. Exhibit 13 is admitted.
Thank you.
Yes.
Okay. So, what is Exhibit 13, Ms. Littleton?
It looks like a notice of violation for exceeding the arsenic maximum contaminant level.
Anything else contained in that notice of violation?
That they had been bypassing the industrial treatment plants, Sunland Park and Santa Teresa arsenic treatment plants.
This notice of violation describes the legal requirements of CRRUA to provide notice to its customers and consumers.
Yes.
How long do they have under this notice of violation to provide notice to their customers and consumers?
It shows in here that the notice must be provided within 24 hours.
Did they provide notice within 24 hours of this violation, Ms. Littleton?
I am not sure if they did or not.
Okay. I'd like to next direct your attention to NMED's Exhibit 15, which there, let me know when you have it in front of you.
Yes,
I will lodge one objection, is that 15 appears to be a duplicate to Exhibit 12. I was kind of operating under the assumption that they would go sort of chronologically. So I think if we admit 15, there's no objection, we strike 12.
It does appear to be a duplicate.
Oh, okay. My apologies, Madam Hearing Officer. I did not sure I'd done that. Thank you.
Which one would you like to admit?
I'll admit 15.
All right.
There's no objection.
No objection. As long as 12 is
withdrawn.
Did I have two questions? All right. What is exhibit number, NMED's exhibit number 15, Ms. Littleton?
It's a 2023 sanitary survey report to Camino Real.
Yeah. But Madam Hearing Officer, just to be clear, I'd like to move exhibit 15 into evidence.
Exhibit 15 is admitted.
Thank you. Ms. Littleton, what does the letter describe, Exhibit 15 describe about the sanitary survey conducted by NMED on December 5th and 6th, 2025?
It says that 58 significant deficiencies were identified.
Is 58 significant deficiencies a lot of deficiencies in your experience?
It is, but they have a lot of facilities identified that are attached to their systems. But yeah, 58's a lot.
Okay. What happened after the 2023 sanitary survey was completed and those 58 significant deficiencies were found?
Once we provided the survey report to Camino Real, they were required to correct the significant deficiencies by the timeline that we set for each significant deficiency. So each deficiency within the report had a timeline.
So was it the same timeline that you described earlier of 30 days for notice and 120 days to correct?
No.
What made you decide to issue a different timeline?
There was a lot going on with pH issue, a lot of media. There was a lot going on with the system, and we wanted to ensure that they were providing safe drinking water to their customers sooner rather than later. And we didn't want to give the regular 120 days for them to do anything to get their system back in shape, basically.
Did that have anything to do with what you described earlier as your lack of trust for CRRUA?
Yes.
Is it fair to say that after the report identified those significant deficiencies, let me ask it this way, I'm sorry. After the report identified the 58 significant deficiencies, did CRRUA correct those on time according to the timeline that you provided for them?
No, they did not. Not all of them.
Okay, so some were corrected?
Some were corrected.
Okay. Did you issue a notice of violation for failing to correct the deficiencies according to your timeline?
Yes.
Was CRRUA notified? So they were notified of the violations for their failure to timely correct significant deficiencies, correct?
Yes.
Okay. And did you issue one notice of violation, or was there a series of notices? Do you remember?
I don't.
Okay. Ms. Littleton, if I represented to you that there were a series of notice of violations issued, would you have any reason to not believe that?
No, I would believe that because each deficiency had a different due date, so we potentially issue multiple.
Okay. Ms. Littleton, can you please turn to NMED's Exhibit 18 in the notebook in front of you? I'm sorry, which exhibit? 18? No objection.
Exhibit 18 is admitted.
Okay. Ms. Littleton, what is NMED's Exhibit 18?
It is a notice of violation to Camino Real for failing to correct significant deficiencies identified in the 2023 sanitary survey.
And what was the date of the notice of violation?
March 7th, 2024.
What does Exhibit 18 indicate about CRRUA's correction of the significant deficiencies identified during the 2023 sanitary survey?
That they failed to correct the deficiencies before the required due date.
Okay. Next, I'd like to direct your attention to NMED's Exhibit 19. Let me know when you have that one in front of you. No objection.
Thank you. Exhibit 19 is admitted.
Yes.
What is NMED's Exhibit 19, Ms. Littleton?
It's another notice of violation to Camino Real for failing to correct significant deficiency identified in the 2023 sanitary survey.
And what is the date of that notice of violation?
April 10th of 2024.
So you issued one in March 7th, 2024, and then another one on April 10th, 2024. What does NMED's Exhibit 19 indicate about CRRUA's correction of the significant deficiencies identified during the 2023 sanitary survey?
That they failed to correct the significant deficiencies by the due date that we set for them.
Ms. Littleton, we're here today regarding the administrative compliance order that was issued to CRRUA, correct?
Yes.
And is it also your understanding that the administrative compliance order was originally issued to CRRUA on March 1st of 2024?
Yes.
So then, would that mean that CRRUA remained out of compliance with the requirements to correct the significant deficiencies from the 2023 sanitary survey even after the administrative compliance order was issued?
Yes,
And that's because the ACO was issued on March 1st, and this letter, Exhibit 19, was issued on April 10th, correct?
that's correct.
Thank you. As we sit here today, Ms. Littleton, out of the 58 significant deficiencies identified in December of 2023, have they all been corrected?
No, they have not.
How many still have not been corrected?
There are 2 deficiencies that have not been corrected.
And do you know what those 2 are?
Failure to have a SCADA system on the treatment plants and soil erosion of an overflow line at the storage tank.
Okay. Was the installation of the SCADA system or the automatic alarm system required to correct the significant deficiencies identified in the 2023 sanitary survey?
Yes,
And that deficiency, as you just testified, still remains outstanding as of today.
yes.
Okay. Following the 2023 sanitary survey, did you issue any notices of violation to CRRUA which were not related to the failure to correct the those 2 significant deficiencies that were left?
I believe I have.
Do you know what they were for?
For failing to collect lead and copper samples from distribution.
Okay. And anything else?
Not that I can remember.
Let me direct you to NMED's Exhibit 11 in that book. You'll turn backwards. No objection.
And Exhibit 11 is admitted.
Thank you. Ms. Littleton, what is NMED's Exhibit 11?
It's a notice of violation to Camino Real for exceeding the arsenic MCL during the 4th quarter of 23 at the Industrial Park Arsenic Treatment Plant.
So, what is the date of that notice of violation?
December 11th, 2023.
And what does this notice of violation indicate about the levels of arsenic at the Industrial Park Treatment Plant?
That the running annual average at that location during the 4th quarter of 2023 was above the MCL.
And do you know what level that
This one was at 25 parts per billion.
and as a reminder, the MCL is 10 parts per.
Yes.
Okay. Next, can you please turn to NMED's Exhibit 20? No objection.
Exhibit 20 is admitted.
Thank you. What is Exhibit 20, Ms. Littleton?
It is another notice of violation to Camino Real for exceeding the arsenic MCL during the 2nd quarter of 2024 at the Industrial Park Arsenic Treatment Plant.
Okay. So, Ms. Littleton, what was the date of that notice violation?
April 19th of 2024.
Okay. And what does this notice of violation indicate about the levels of arsenic at the Industrial Park Treatment Plant?
That they exceeded the arsenic running annual average MCL.
And what do you know what the level was?
It was 28 parts per billion.
So from the earlier exhibit that was from December 11th, it was 25 parts per billion. Now it had actually increased to 28 parts per billion.
That's correct.
So the running annual average of arsenic at CRRUA's Industrial Park Treatment Plant nearly tripled the MCL level in the 2nd quarter of 2024.
Yes.
Ms. Littleton, thank you very much. I have no further questions for you at this time.
Okay, thank you. Mr. Trujillo or Ms. Carey? Okay.
Yes. And Ms. Littleton.
you please take a look at NMED's Exhibit 6? Can you please look at paragraph 6 of Exhibit 6? This paragraph, have you read it? This paragraph states that the 2008 compliance orders are hereby replaced with this order, correct?
Yes.
Did you introduce Exhibit 9? I believe you did, right?
Yes, it
Yes.
was admitted.
Okay. Can you please take a look at paragraph 45 of Exhibit 9?
Exhibit 9. Is it the sanitary survey report?
I'm sorry.
You're looking at?
Page
I have a 45.
45, paragraph 45 of Exhibit 6. I'm sorry, it's a typo.
Yes, I see it.
And that paragraph states that, quote, all violations contained within this order are outstanding violations from the Sunland Park SFO, Industrial Park SFO, Doña County ACO, and Santa Teresa ACO. Is that correct?
That's correct.
And you're aware that CRRUA and NMED entered into a settlement agreement to resolve this specific ACO, are you not?
Yes.
Yeah, approach. Ms. Littleton, I'd like to show you what's been marked as CRRUA Rebuttal Exhibit 1, which is the stipulated final order in Drinking Water Bureau 1615, dated October 24th, 2016. Are you familiar with this document?
I am not.
Okay. You've never seen this document before.
I don't believe I am.
And so you were not aware that that CRRUA and NMED entered into a stipulated final order in response to the administrative compliance order in DWB 1615.
I was aware of it, but I don't take part in any of that. I don't handle any of the administrative orders or you know, the process for them. So I was aware of it, but I don't know like what's in the document.
Okay. You were aware that there was a stipulated final order.
Yes.
Okay. Is there any objection to the admission of Rebuttal Exhibit 1615?
The only, I don't know if it's an objection. The only thing I'd like to ask is, are you going to admit the 2 extensions to this?
Yes.
Okay.
We can do that. We can do that right away.
Okay.
Well,
Yeah. Then I have, if that's the case, I have no objection. Okay.
All right. CRRUA Rebuttal Exhibit 1 is admitted.
Thank you.
Madam Hearing Officer, are you going to just include these 2 extensions as part of Exhibit 1?
Well, they're marked as 1, 2.
Oh,
yeah.
Okay. Okay.
I'll see how they marked. Yeah. Thank you. Great. So CRRUA Rebuttal Exhibit 2 is admitted and CRRUA Rebuttal Exhibit 3 is also admitted. These are the First and Second Amendment extending the settlement.
CRRUA rebuttal exhibit number 1, which the stipulated final order sets forth a penalty of $1,000 to be paid by CRRUA in paragraph 10. Do you see that?
Yes.
And paragraph 12 in that same document sets forth a corrective action measure, action measures, correct?
Yes.
And those measures included pursuing funding, a corrective action plan, and deadlines for compliance with the arsenic standards at each of the 4 arsenic treatment plants, correct?
Yes, correct.
And the settlement agreement was signed at the very back by the Secretary of NMED at the time, correct?
Yes.
And if you turn to CRRUA's rebuttal exhibit number 2, the first amendment to settlement agreement between NMED and CRRUA, appreciate it.
Okay, I think I have it. Exhibit 2?
Sure.
Exhibit 2 that we're looking at? Okay.
And that was signed by Secretary Kenny on July 27th, 2020, correct?
Yes.
And paragraph 1, first page of the first amendment to the settlement agreement, states that all corrective measures set forth in the settlement agreement were resolved by CRRUA relating to all of the treatment facilities except for the border region, correct?
I'm sorry, where are you looking at?
Paragraph 1.
Paragraph 1 of the exhibit 2?
Of the first amendment of exhibit 2, yes.
Okay. Okay. Can you ask your question again? I'm
Sure.
sorry.
Paragraph 1 of the first amendment to the settlement agreement states that all corrective measures set forth in the settlement agreement were resolved by CRRUA relating to all of the treatment facilities except for the border region, correct?
Correct.
And this first amendment to the settlement agreement sets forth the agreement between CRRUA and NMED to extend deadlines relating to the border region arsenic treatment plant, correct?
I don't know where you're finding that out.
Madam Hearing Officer, I'm going to object. She already said she's not familiar with this document. And is not sure.
We can go to the exact.
Also, I mean, the documents speak for themselves as well. Unless you're setting up a question, she can answer.
If you look at paragraph 5 of page 3.
Okay.
The parties agreed to extend the deadline outlined in section 3, paragraph 2D, 12D of the SFO from December 31st, 2018 to December 31st, 2022, and extend the deadline outlined in section 3, paragraph 12F of the SFO from December 31st, 2019 to December 31st, 2023. Correct?
Correct.
And there are stipulations there, correct?
Yes.
And as part of those stipulations,
Madam Secretary, I'm going to object. This is outside the scope of my direct. The documents that she's already testified that she lacks the foundation to testify about these documents, and the documents speak for themselves, as you said. So it's just a waste of time. He's entered them into the record, and the questions have already answered themselves, basically.
All right, Mr. Trujillo, are we doing something productive here?
What we're trying to do, Your Honor, Madam Hearing Officer, is the testimony by Ms. Littleton has been that there's an administrative compliance order. There's some very serious allegations in it. But what CRRUA is trying to represent by these documents is that this is not the entire story, that there is a second part of that story, which Ms. Littleton may not be the right person to testify to. So to the extent that they're entered into evidence and that CRRUA can preserve its right to make an argument that that NMED has not fully fleshed out the entire backstory of 1615.
All right.
We can move on.
You can certainly make your arguments regardless of what testimony she's able to give. All right. Thank you for moving on.
Ms. Littleton, did you issue the administrative compliance order against CRRUA in March 1st, 2024?
I did not.
You issued the notice of the violation, correct?
Yes.
And those notices of violation then resulted in an administrative compliance order.
Yes.
You testified that you have a range for your position of I-40 South, in other words, the entire southern half of New Mexico.
Yes.
How many water systems do you oversee, if oversee is the right word?
I have a staff of 4, and my staff and I oversee approximately 400 public water systems.
And in regards to the sanitary survey 2019 that you testified about, all of the significant deficiencies in that have been resolved, correct?
As of today, they have been resolved.
In regards to the significant deficiencies that you mentioned of the 2023 sanitary survey, those significant, actually, let me hand this to you. Are you familiar with the second amended compliance order in this case?
No.
May I approach?
Madam Hearing Officer, same objection. She is unfamiliar with the document. She lacks foundation to testify about it. And it's already in the record. And
she just said she is familiar with it.
No,
oh, you're not
She's
familiar
not
with
familiar
it.
with the document.
That's a second amendment. I have it.
And it's already been admitted. It can speak for itself again. And
I'm not seeking to introduce it as an exhibit. It's just for her information.
but again, lack of foundation, Madam Hearing Officer.
So what questions will you be exploring with her?
The significant deficiencies that CRRUA was obligated to correct as a result of the administrative compliance order. Are you familiar with them?
I'm familiar with the significant deficiencies, but I don't really know which ones you're referring to because I don't really have any knowledge of the administrative compliance orders.
So same objection, Your Honor.
I understand.
We'll move on to a witness that has knowledge. In regards to Exhibit 20, for the second quarter of 2024, an RAA of 0.028, Burrell noted that this had actually increased. Are you familiar with the arsenic test results that CRRUA has been engaging in since January of 2024?
Are you talking about compliance samples or special samples?
The voluntary arsenic test.
I am aware of some of them. I know they send them. My compliance officer is the one who more focuses on those and reviews those. I focus primarily on the actual compliance samples.
Okay, so who is the compliance officer who reviews those?
Tim Willie.
Okay. And so in regards to the compliance samples, are you familiar with the test results that have been collected by NMED since January 2024?
The compliance samples, yes.
Okay. And what have the results of those compliance samples been? What have they been since January 2024?
Well, this report right here is from the second quarter of 24. So they were over the MCL during the second quarter of 2024. It appears that they were also over the.
I'm sorry, let me get the right document. I apologize. Can you explain to us what your role is in regards to the compliance samples and the BD?
My role is in, I just receive the results, and we don't analyze the data. We just get the data from the lab, and then we determine if their running annual average is above the MCL, and then we issue the violations.
So you're aware then of that NMED collected a quarterly compliance sample on April 3rd, 2024?
Was it for the second quarter? Was it for the third quarter?
Second quarter of 2024.
So I'm not sure what date the sample was collected, but we issued them a violation on April the 19th of 2024 for the second quarter of 24.
Correct.
Mm-hmm.
And so what was the individual test sample for April 3rd, 2024? Do you recall?
Objection.
I don't.
Madam Secretary Sherrod asked an answer. She doesn't know the answer to that.
Okay. It just said no again.
Ms. Littleton, discovery in this case, CRRUA submitted requests for admission to NMED. Did you have any, were you consulted in response in regards to the responses to those requests for admission?
No.
And I'm going to represent to you that in those requests for admission, NMED admitted that NMED admitted that it collected individual quarterly test samples from the Sunland Park Arsenic Treatment Plant, the Santa Teresa Community Arsenic Treatment Plant, the Industrial Park Arsenic Treatment Plant, and the Border Storage Arsenic Treatment Plant. That's standard protocol for your office, correct? Is to collect quarterly compliance samples from each of those treatment plants.
Yes.
I was just going to object that she already said that she lacked a foundation. She was not consulted about the RFAs.
Right.
No.
That's not the question
Okay.
he asked. That's
Yeah.
what we're ruled. Go ahead, Mr. Trio.
And NMED admitted that it collected those quarterly test samples at those 4 locations on April 3rd, 2024, July 3rd, 30th, 2024, October 22nd, 2024, January 28th, 2025, and May 7th, 2025. That has been admitted. Do you have any reason to doubt that?
I don't know when the samples were collected.
Right. But do you have any reason to doubt that what NMED has already agreed to is false?
I don't have any reason to
So
doubt that.
when NMED collects those individual samples from 4 different tests, from 4 different arsenic treatment plants, that's 4 different samples per quarter, correct?
It's 4 different samples, 1 per entry point.
I'm sorry?
1 per entry point.
1 per entry point.
Yes.
In other words, per arsenic treatment plant.
Yes.
And NMED has admitted in the request for admission that the dates that I just read to you equal 20 individual test samples from 4 different arsenic treatment plants. Do you have any reason to doubt that?
I don't have any knowledge of it, but I don't have any reason to doubt it.
You said that you received the results for the compliance. In fact, you said that that is your main focus. It's not the voluntary test, it's the compliance sample. You receive those, you follow those, you track those.
Yes. Yes.
And so
I do that.
I'm asking
I'm not sure if it's 20. I mean, it could be 20, but I've never counted them to know. But I mean, that sounds 4 per quarter.
Yep. Sounds like 16 to me.
Yeah.
And if you would be careful not to step on the end of his sentences. Okay.
What I'm saying is that what NMED has admitted is that since April of 2024, they've collected 5 quarterly samples. April 3rd, 2024, July 30th, 2024, October 22nd, 2024, January 28th, 2025, and May 7th, 2025. That's 5 separate quarters. Correct?
Yes.
And so that would be 20 individual compliance samples since April 2024, correct?
Objection, Your Honor. She's already said she doesn't know how many she never counted them.
Okay, I think he's asking if there were 4 in each of 5 quarters, is that 20?
Yes.
And NMED has admitted that of those 20 individual samples, do you know, have you tracked which of those 20 individual samples, what the results were, positive or negative? Are you familiar?
I have 2 violation letters that were issued right here that shows that 1 sample in the second quarter of 24 was exceeded the MCL, and 2 samples during the third quarter of 24 exceeded the MCL.
Of 2020?
Of 2024.
Correct.
Mm-hmm.
I'm saying those are the compliance samples, the RAA, right? I'm talking about the individual compliance sample, that not the RAA, the individual compliance sample that was collected. Are you familiar with those results? Do those results get transmitted to you? Like what the individual, not what
results get. Oh, I'm sorry.
You have to wait for him to finish asking. Go ahead, Mr. Trujillo.
I'm not talking about the running annual average. I'm talking about, because I think that the running annual average is based on exactly that. You add the averages for that year, correct? And how would CRRUA go about lowering its running annual average?
So the running annual average is calculated using the 4 quarters of sample results. And so we take the 4 recent quarters of the sample results and divide them by 4, and that's the running annual average. When a new sample is collected, the 1 sample, that sample takes the place and the last sample collected drops off. So it's a rolling running annual average of it. So the samples that you're talking about that were collected, they were individual samples, but they were incorporated into the running annual average.
Thank you. In other words, the only way for CRRUA to reduce its running annual average below the MCL is to have a series of quarterly compliance samples that drop incrementally, correct?
Yes, that's correct.
And so If CRRUA was at a 0.028 in April 2024 and achieved compliance with the running annual average in January of 2025, what that means is that over the course of that period of time, CRRUA's compliance samples on an individual quarterly basis incrementally decreased the running annual average until they finally came into compliance, correct?
That is correct.
So that means that starting in April of 2024, up until January of 28th of 2025, CRRUA's individual quarterly compliance samples slowly but surely decreased its running annual average until it became compliant with the arsenic standard on January 28th, 2025.
I believe that's correct.
Thank you. And, I want to, this is nerve wracking, and it's not just nerve wracking for you, it's nerve wracking for us too. But what we're trying to get at, I think, is exactly what you're testifying to, because you would know, because you're the Southern Compliance Supervisor for NMED, and you deal with CRRUA on a regular basis, correct?
Correct.
And CRRUA is currently staying in compliance with the arsenic standard, right?
Madam Hearing Officer, is he asking a question or is he testifying? He's telling her what she knows, etc.
Okay, so he's allowed to lead because it's cross.
Yeah, but that's different than telling her what she knows.
He just asked.
Okay.
You can tell her what she knows and then ask her if it's correct. And then she answers, it's correct or it's not correct.
Right.
That's the leading question.
I know what the leading question is, Adon. I'm telling you that you were telling her what she knew, but you weren't asking a question. Maybe you got the question while I was trying to object. Maybe I didn't hear it.
Okay, so he asked if you were in agreement with his last statement. Do you need him to repeat it?
Yes, please.
And so CRRUA is in compliance with the arsenic standard, correct?
Correct.
And you would know that as the Southern Compliance Supervisor,
Yes.
right? And you would know that where you sit today, that CRRUA is in full compliance with the arsenic standard at all of its entry points.
Yes.
And so you work regularly with CRRUA on a regular basis. I assume you know Juan Carlos Crosby?
Yes, I do.
And you know he's the executive director of CRRUA. So you think JC is doing a good job, right?
I think that after the action that we were taking toward them, I think that he is doing his best to maybe bring the drinking water system into compliance. I don't know, because my feeling is that I mistrust the system enough that I'm not quite sure. I'm not quite convinced yet.
But you said bring the system into compliance. The system is in compliance. So JC has done a good job of bringing the system into compliance, right?
Objection asked and answered. She answered the question.
Right. He, I think, is just trying to force her answer. Go ahead, Mr. Trio.
He's asking the same question over again, Your Honor.
Okay. One more time, Mr. Trio.
It's not the same question, because I'm taking the testimony. You said that they're doing a good job to get them into compliance. I'm saying the system is in compliance. You've
With
testified
MCL.
the system is in compliance with the MCL. And so JC, based on the administrative compliance order, he's done a good job of getting the system there, right?
She didn't testify to that. She said they're in compliance, but she said she doesn't trust the system. She didn't say that JC is doing a great job.
I'm asking her that. That's what I'm asking.
It doesn't sound like you're asking questions. It sounds like you're telling her what.
Mr. Ray. Please don't talk over Mr. Trujillo. Please don't talk over Mr. Trujillo. And Ms. Carey, please don't talk over Mr. Trujillo. Mr. Trujillo, let's get through this a little more quickly, please.
But I'm trying to ask her the question.
All right.
I mean, so the system is in compliance. And so you'd agree that JC's done a good job in getting the system into compliance?
That's that answer.
She hasn't answered the question.
She has, Your Honor, read back from the record. He asked that question. She answered the question. He continues to ask the question to try to get her to say JC's a great guy and he's doing a great job, but she's already answered that question.
All right. So, Mr. Trujillo, what I heard her, hold on. What I heard her say was that she thought he had done a good job of getting the system into compliance, but that she, based on obviously previous stuff, doesn't yet trust the system entirely, right?
I didn't hear that. I didn't hear you say he's done a good job. Did you say that?
Wait.
Yes.
I think that
I'm
they
asking that.
have
Yes, sir.
returned back to
Did you say he's done a good job?
Mr. Trujillo,
I just want to move on.
I know. Yeah. She was answering the question and now you're interrupting her. Let her finish her answer.
These are leading questions that there can be a yes, but, no, but,
Yeah.
but we're trying to make a record.
She was trying to answer. Ms. Littleton.
Let me ask you a different question. Mr. Crosby's doing a better job than Brent Westmoreland, right?
yes,
Easier to work with than Brent Westmoreland?
yes,
Much more responsive than Brent Westmoreland?
yes.
Much more trustworthy than Brent Westmoreland? You don't
It's
know
up
yet.
for debate. I don't know yet.
But you have a better working relationship with JC than you do with Brent Westmoreland.
Yes,
You don't feel that JC's ever lied to you, do you?
yes, he has.
What about Eric Lopez? You know Eric Lopez,
Yes,
right? And you know that he's a contract water, wastewater operator level 4 for CRRUA, right?
yes,
And that you know that he most recently came on board with CRRUA directly in response to the December 2023 PH incident. That's one of the bases for this administrative compliance order, right?
yes,
In other words, he hadn't been there for some time, correct?
yes,
Or he was in there in the past, then he left, or he came back. But you had known Eric Lopez from before then, right? Before 2023, you knew Eric Lopez.
yes,
And you've been to trainings where Eric Lopez has presented for continuing educations, right?
yes,
And so you respect Eric Lopez's expertise, right?
yes, I do.
And you think Eric Lopez is working hard to address the issues that CRRUA has, right?
Yes,
You think JC is working hard to address the issues that CRRUA has, right?
yes,
And you're familiar with the circumstances of the compliance order in this case, or you're not
I
familiar?
am not.
But you do know about the allegations about the arsenic systems being offline,
Yes,
because you issued notices of violation for that.
yes.
And you know about the pH issue when a sensor malfunctioned.
I'm aware of it, but I wasn't there at the time for it.
Well, you know that all of this kind of came to a head in December 2023.
Yes,
And CRRUA today is in a much different place as you sit there than it was in December 2023. Wouldn't you agree?
yes,
And CRRUA has worked hard since December 2023 to come into compliance. Wouldn't you agree?
yes,
And CRRUA isn't being run the same way as it was in 2023 as it is now. Wouldn't you agree?
I'm not sure.
I was gonna say objection, asked and answer, said she wasn't sure.
Okay, thank you.
Well, there's still things to fix, but CRRUA is much more successful today than it was in December 2023. Wouldn't you agree?
Same objection, Madam Hearing Officer. It's just trying to reframe it in a different way.
Okay, Mr. Trujillo, it is getting repetitious.
Okay. I mean, what we're trying to narrow down is specific time periods of, I mean, what they put on evidence is that CRRUA has this history of non-compliance, and that Director Roderick has testified extensively that CRRUA is complying and then back out of compliance. But the fact of the matter is that what we're trying to put on evidence is that this is a different time and it's a different period. And I think that Ms. Littleton is qualified to give that testimony based upon her longstanding actual working history with CRRUA.
And Madam Hearing Officer, Ms. Littleton has already testified to that. She said she's not sure, She said Mr. Crosby has lied to her. She said she trusts and respects Mr. Lopez, but she's answered the question that she's not sure yet whether or not CRRUA is the wonderful organization that he is painting it out to be. She's
Right.
the answer.
Again, it's become repetitive.
She also testified that CRRUA has done a good job since December of 2023 to come into compliance. And you would say that CRRUA is probably vastly improved from where it was in 2016 when you issued that administrative compliance order, wouldn't you?
Oh, back to me? I'm sorry. What was the
Okay.
question again?
Well, you'd also agree that CRRUA is vastly improved where it was from 2016 when you issued that administrative compliance order of those notices of violation. Wouldn't you agree?
Yes, but CRRUA also has a history of doing great and returning back to compliance. And then as soon as we look away, they bypass the treatment plants and start the process all over again of providing unsafe drinking water to their customers.
Thank you. We're going to get there. And because you know that CRRUA is using arsenic test strips on a weekly basis to test their drinking water, right?
I don't know that.
You would agree that if they are doing it, they're not obligated to do that, right?
That's correct.
And you'd agree that that's good faith on the part of CRRUA if they're doing that, right?
Yes.
And you know that CRRUA is doing monthly voluntary arsenic testing through a certified lab. Is that correct?
Yes.
And that's the same lab that NMED uses for its compliance testing, right?
Yes.
And so you know that CRRUA is doing this testing to try to make sure that they stay in compliance and catch issues early?
Yes, this would be part of what should be their regular practice of ensuring that their treatment plan is running properly.
You said you operate or you oversee 400 water systems. How many of them do individual voluntary tests on a monthly basis?
I am not sure of the number. They're not required to provide those special samples to us.
Are you familiar of any that do that?
I'm not sure.
You know that CRRUA for a time was doing voluntary arsenic testing twice a month, right?
No.
I don't know. Do you receive all of the results of the voluntary tests or do you not?
I do. I don't know if I receive all of them, but I do receive some of them.
When you say you don't know if you receive all of them, what does that mean?
I'm not sure, like when they come in, I don't know if they come in quarterly or monthly, or I do see them come in. While I see them come in, I realize that they're special samples, so I don't really focus too much on those. I focus more on the actual compliance samples. So, I mean, the person who would actually take a look at those and monitor those results would be the compliance officer.
Okay, the compliance officer again is Tim Willie.
Yes.
Anyone else?
It just depends on who they would see those results to.
So it's fair to say then that you're copied on lots of emails from
Yes.
CRRUA with arsenic testing, but you don't really pay attention or really track it.
Yes, that's correct.
You have staff that does that for you. Okay. Well, then what I'm going to represent to you is that in the course of this litigation, NMED has admitted that you don't have to. The CRRUA has collected voluntary arsenic tests on January 24th, 24, February 7th, 24, March 6th, 24, March 18th, 24, April 2nd, 24, April 16th, 24, May 8th, 24, May 21st, 24, June 11th, 24, July 2nd, 24, August 21st, 24, September 10th, 24, October 1st, 24, November 5th, 24, December 3rd, 24, January 9th, 25, February 28th, 25, March 21, 25, April 23rd, 25, May 6th, 25, May 14th, 25, May 21st, 25, June 10th, 25.
Officer, we'll stipulate to what's contained in the request for admissions. She's already testified. She's not familiar with those documents. Does not have the foundation to answer those documents, and those documents speak for themselves.
I haven't asked a question yet.
Right. I imagine there's a question that follows what he just said. We're going to listen for that question. Go ahead, Mr. Trillo.
Thank you. So what I'm representing to you is that on all of those dates, NMED has admitted that CRRUA took voluntary test samples at 3 of its arsenic treatment plants, and that those individual samples add up to 69 individual test samples. Okay.
Okay.
And then 5 of those NMED has admitted were above the MCL for arsenic. And what I'm going to ask you is that in the past year and 8 months, where CRRUA has performed voluntary testing for arsenic through a certified lab that it was not required to do by NMED, those voluntary arsenic tests only exceeded the MCL for arsenic 6 times out of 69, right?
Objection. She
Right.
doesn't know the answer.
Right. That's what you're representing to her. Now, what's your real question?
We would agree that that type of success rate contributes to how CRRUA was able to reduce its running annual average below the MCL ahead of time, right?
Yes.
And you know that it was required to lower its running annual average below the MCL by March 31st, 2025, right?
I don't know that. Is that in the administrative order?
If you don't know that.
I don't know. I don't know that. I don't know the date.
But you are personally aware, because you testified that this is your job, that NMED has conducted another quarterly test sample in addition to the test samples that I stated in July 2025, correct?
I'm not sure.
You don't know if NMED did a quarterly test sample in July 2025?
I don't. I wouldn't collect the sample, so I don't know when they were collected. If the result was not over the MCL, then I wouldn't see the sample.
Say that again. If the results were not over the MCL, you wouldn't see the sample.
Yeah, because it wouldn't be triggered if you weren't over the running annual average.
So you don't remember seeing a sample, so it probably didn't go over the running annual average.
She can't say. She doesn't know.
I know you're not familiar with the April 23rd and the May 6, 2025 test results, but you didn't issue notices of violation to CRRUA in regards to any voluntary testing, correct?
That's correct.
And you didn't, like, if you take a look at your exhibit 18, at the bottom of the page, at the bottom of page 1, you mentioned that public notice must be made within 30 days from the date of this letter. Do you see that in the second to last paragraph?
Yes,
And this was for this violation in particular was what for what? A groundwater rule?
this was for not, oh yeah, for not correcting the significant deficiencies by the required due date.
So if CRRUA had violated the MCL through its running annual average being above the MCL, what kind of notice would you give them to inform the public?
It would also be a tier 2 public notice for exceeding the MCL,
So what's the tier to public notice? How much time is that?
30 days.
So they'd have 30 days
Yes,
to inform the public.
yes.
So in other words, CRRUA would have been in compliance if they had issued that notice on the 29th day.
Yes.
I believe in another one of the exhibits, I think it was in one of your 2016 NOVs, you gave CRRUA notice that they had to, you required CRRUA to notify the public within 1 year of the date of your letter. You recall that?
I don't know which letter you're talking about.
I believe it's the July 16, 2000 notice of violation, NMED's Exhibit 7.
Okay.
So in that situation, NMED gave CRRUA 365 days to comply, right?
Yes, this was for a missed sampling plan. They didn't have an approved sampling plan for the revised total coliform rule. And so they were issued this violation for not having that plan approved. And it required 100-day public notice.
Yeah, are you familiar with the ERG report that Cabinet Secretary Roderick testified about earlier?
I'm not.
Were you on a site visit for the third-party evaluation of CRRUA's arsenic treatment process?
Are you talking about the CPE?
Yes.
Something like that? Yes.
You were there.
I was there for a day of it, I believe.
And are you aware of the circumstances of how that came about?
No, not really. No.
Okay. Are you familiar with the AWOP program?
No, I'm not.
Are you familiar with the fact that CRRUA has reached out to NMED regarding board training, regarding its board members' roles and responsibilities?
No, I'm not.
Are you familiar with a separate training that NMED conducted based upon CRRUA's request to regarding an emergency response plan?
No, I'm not.
Are you aware that CRRUA has adopted any SOPs, standard operating procedures that were approved by NMED?
Yes.
And as part of those SOPs, CRRUA developed a daily arsenic treatment form. Are you aware of that?
No.
You don't recall Eric Lopez showing you a copy of that form template at the ERG site visit?
I remember seeing a rough draft of a daily worksheet that they were attempting to put together.
So you're not aware that NMED has approved the form of that daily arsenic treatment form?
Asked and answered.
I think she did answer that
already. I asked if she was aware that NMED had approved the form.
All right.
No.
And are you familiar with the fact that as part of its SOPs and the daily arsenic treatment form that CRRUA has trained its arsenic treatment plant staff to fill out those forms on a daily basis?
No, I'm not.
You are the compliance
Yes.
supervisor, and you're not aware of this.
No, they would work directly with their compliance officer,
And the compliance officer is Tim Willie.
Tim Willie.
And Tim Willie has not communicated this to you.
No, he wouldn't.
Sorry?
He would only communicate it to me if he had issues with it, he needed me to review something.
So then you're not aware that CRRUA takes those daily forms and inputs them all into a database that tracks the trends for CRRUA's arsenic treatment, including pH levels, chemical dosages, treated arsenic levels, daily chlorine, raw and finished water?
You're
Mr. Trujillo, you speak too fast for the
I apologize. I know it's 4:52. Dosages, treated arsenic levels, daily chlorine, raw and finished water. Correct.
No.
Thank you. No further questions.
All right, thank you. We don't have a lot of time in the event you have redirect.
Your Honor, I do have redirect. I'm not sure I can do it in 4 minutes.
Okay.
I don't want to make and stay another day, but I don't think I can do it in 4 minutes.
Okay, maybe just ask a couple of questions then, so we get close to 5 here.
Okay. If I may just have a minute.
Oh, all right.
Ms. Littleton, the SOPs that Mr. Trujillo referred to, those were adopted after this enforcement action, correct?
I believe so.
Would you consider that to be proactive or reactive on part of CRRUA?
Reactive.
Is your experience, your extensive experience with CRRUA, one where they are proactive or reactive in general?
Reactive.
You testified earlier that CRRUA has that you were not sure whether or not Mr. Crosby and CRRUA have turned things around completely because they have a history of going in and out of compliance. Has that been your experience with CRRUA in the entire time that you've been compliance officer?
Yes.
And do you have any reason to believe that that is going to change? Have they, let me ask it this way, have they given you any reason to believe over the last 15 years, or, well, I guess you've been compliance officer 10 years, 9 years. Have they given you any reason over the last 9 years to believe that that is going to change?
No.
Ms. Littleton, if CRRUA had we talked earlier about the unresolved significant deficiencies that were the two unresolved significant deficiencies, one of which was an automatic warning system, or a SCADA system, as you described it. If CRRUA had installed an automatic system such as a SCADA, would the manual tests that CRRUA is touting and tooting their horn about right now, would they be necessary?
No, not if it was automatic.
And why is that?
Because it would be automatically taking readings and providing the data.
And what would that accomplish?
It would, the SCADA system has built-in alarms. And so if you would set a limit in there that the arsenic was increasing, and then it would notify whoever you have programmed in there, which is usually primarily the operators of the system, that the arsenic levels were increasing so that they could make adjustments to the treatment plant.
Would it also have caught, for example, the pH issue?
Yes.
So if I understand the way a SCADA system works, you could set an alarm for, if we're talking about the arsenic MCL, you could set an alarm for 8 parts per billion. And if it starts to exceed that, they would automatically be notified and could then take action to prevent it from exceeding the MCL?
Yes, the SCADA systems, they can be pretty extensive. They can have alarms set for everything, including opening the doors to facilities and storage tank hatches, to the amount of chemicals that are introduced into the system, if probes are not working, those type of things.
Would it also notify you, or could you set an alarm in the SCADA system that would notify you that the arsenic treatment plants had been bypassed?
Yes.
It would notify you that they were not working, basically.
It would notify the operators of the system.
And they would be required to notify NMED.
Yes.
Do you believe that one of the reasons that CRRUA has not yet installed a SCADA system is because of such a possibility?
I think you're asking for speculation, I think.
Okay. Do you believe that a SCADA system could have prevented all of the issues related to CRRUA, or at least notified CRRUA timely, and they could have of all the issues that have occurred with CRRUA over the last 15 years?
Yes.
You heard Deputy Secretary Roderick testify earlier about the different funding programs that NMED has for struggling water systems, correct?
Right.
And you also heard Deputy Secretary Roderick testify that a SCADA system is, I believe the words used were very expensive, or quite expensive.
Yes, I did.
Is a SCADA system something that that CRRUA could apply for some funding for?
Yes.
To your knowledge, has CRRUA ever done so?
Not to my knowledge.
Okay, Mr. Real, unless you have just one more question.
I have several.
Okay.
Yeah.
No, I mean.
Oh, yeah, I'm sorry.
5. All right.
Okay.
So we will resume the hearing at 9 o'clock tomorrow morning. We'll pick back up again with Ms. Littleton and Mr. Real. And thank you all very much.
Madam Hearing Officer, off the record, can I just ask a couple of logistical questions?
Okay, we're off the record. Go ahead.
Are we